Before coming up to the topics, we should have some background on the Constitution as a whole and how it is derives its power. What are the sources that will help us in interpreting many of the provisions of the Constitution. So, the Constitution is a supreme law of India, as you know it. The document lays down the framework demarcating fundamental political code, structure, procedures, powers, and etc. Provisions of the law. So it basically says that it is a supreme document based on which all enactment in India should comply with. The constitution was drawn from a number of sources, including the previous legislation, such as the Government of India Act 1858 and other Indian Government Act before India get independence in 1947. So Government of India Act 1935 was a prominent document based on which many provisions have been incorporated in the Constitution. So the judgments and jurisprudence relevant to the previous legislation help the present courts in interpreting how the entries are in the current Constitution. Further, the fathers of Constitution traveled across the world and borrowed many of the principles from other constitutional and charter documents of other countries, and many of the provisions in our constitution derives or borrows principles from the constitution of other countries, so such as fundamental rights and judicial review is borrowed mainly from the constitution of USA. um, France is basically a very liberal countries, so the ideals of the constitution, liberty, equality, and fraternities are the epitome of the French constitution, and we have borrowed that into our constitution. The most important feature of our constitution that it is a quasi-federal format. That this kind of feature is borrowed from the Canadian constitution because they also have a system of quasi-federal. They have a central government and they have provincial government at the state level. So when we see the Constitution of India, many of its jurisprudence have came from the interpretation provided by the courts sitting in those countries. And even in today's regime, those decisions from the other countries provide us some background as to the provision, as to the interpretation of the Constitution of India also. In the taxation aspect, the this taxation regime has seen many contentious constitutional issues in the past, including the 46th Amendment, which was relating to empowerment of sales states to levy sales tax on certain transactions which were erstwhile not covered within the plain meaning of sales. Then we have disputes relating to the states' overarching power in terms of interstate trade and commerce. Article 300A was in pretty much dispute because it was related to property and uh, uh, depriving a person of his property in the form of SENVAT and ITC. So 101st Constitutional Amendment Act, apart from seeking uniformity in the form of GST as we know it, it also tried to address or to an extent eliminate the constitutional disputes that were at the upfront of many taxation statute. So the 101st Amendment Act was important not only in terms of the uniformity of taxes, but it also tries to settle down the constitutional debates relating to taxation regime. With that in mind, I'll quickly come to the first point of discussion, which we have Article 265. Article 265 says taxes not to be imposed, say, by authority of law. It says no tax shall be levied or collected except by the authority of law. So it has three limbs. We'll be discussing one by one. The tax, as we properly call it, is a very unique term, and it has been the point of discussion at various forums and various times by the honorable courts. In one prominent judgment of Commissioner of Hindu Religious Endowments Madras was Sri Lakshmindra Tirtha Seminar of Sri Shurumut, AIR 1952. The court basically held down what a tax is all about. So these four features that we are seeing, that tax is a compulsory exaction of money by a public authority for public purpose. This is the main feature of a tax. It says it is a compulsory exaction of money. Then essence of taxation is compulsion, again flowing from the first feature itself. tax is without reference to any special benefit. So there is no quid pro quo. That is, you don't provide me. The state is not a state is not required to provide any particular service to its resident to exact tax from it. The tax is without any reference to any subject. It is a compulsory exaction, and it is a part of the common burden. It is not supposed to be provided to the person who with some special privilege. It defines some kind of a concept. It defines a particular taxable event, and if any person falls under the taxable event, then it is common for all those persons who satisfy that particular taxable event. In the light of this, there is a difference that is usually highlighted between the tax and fee. So what usually happens in the context of a taxation and fee structure is that the government has wide amplitude of power to enact a taxation, and it can it can try to impose tax at the highest margin possible without uh, and the subjects cannot usually contend that the tax is harsh, it is accessible, or otherwise. While if you see the fee on the other hand is a quid pro context concept. So whenever a state is granting some special privilege to a person, and in that in the reciprocal of that privilege, a certain amount is being recovered from that person. That particular amount is referred to as fee. So when it comes to fee, the quid pro quo context says that the fee should be commensurate with the cost that is being incurred by the legislature or the imposing authority. So it has some kind of a variation in from the taxes point of view in the context in the sense that when it comes to fee, there is some leeway available to the person to contend that this amount of fee that is being collected from him should be proportionate, or at least having some nexus to the special privilege that he is being getting. Now in that context, there is a recent dispute emerging out of this pandemic that has been occurred. The Delhi government has levied special corona fee on the 70% of the MRP value of the liquor that is being sold by the liquor players in Delhi. So there is a question, there is a writ admitted before the Delhi High Court, Honorable Delhi High Court, as to this levy is unconstitutional in the sense that it is not a tax, because the Delhi government itself has not invoked the provision of taxes. And secondly, because this fee is having an excessive burden to the extent of 70% on the MRP, it is denuded of the quid pro context, such that it is so much excessive that the privilege that a person, the seller of the liquor, is getting is very low. So they are arguing, the point of argument before the Delhi High Court is that this special corona fee is in excessive with respect to the privilege that the liquor sellers is usually getting. So we are yet to see as to whether this amount, this special corona fee would survive the test of fee versus test when it comes to the special circumstances that we have been encountered with. Uh, Probably in a sense, it could be said that once the Delhi state would on the one hand might argue that it is not a fee, it is a tax. Then the question on then the table would be on them, if it is a tax, then why the proper provisions of enacting a taxation statute were not invoked, and why this particular fee was invoked as a fee under section 4711 and 7781 of the Delhi Excise Act 2009. So the state is in a paradigm because they have to contest this ground, and they have contest this special fee on the basis of it being a tax, and as well as it being in the nature of fee. On both count, they have uh, some so the liquor sellers have some kind of a leeway available with them, that these 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 corona fee, be it as a tax, is not invoked properly with the Delhi properly under the provisions of Delhi Excise Act. And if the state contends that it is a fee, then there is a lack of quid pro quo, or the quid pro quo is not proportionate to the special privilege that the Delhi government is providing to the liquor sellers. So we have this dispute in this regard. Uh, I would request Naveen sir to jump in, or else we could take his comment once this topic is over. Naveen sir. Okay, he's on mute right now, so
Yeah.
we'll be proceeding forward. Yeah. Yes, sir.
Hello,
Yes, sir. You're
Manish.
audible, sir.
Article. This is continuation of Article 265. You complete that, then
Yeah.
I'll come.
Okay. So very fine, sir. So Article 265. Once we have discussed the tax part of this article. Now the article also says that tax should be imposed only, should be levied and collected only with the authority of law. S. Gopalan versus State of Madras is a very landmark judgment on the authority concept of Article 265. It says law means an act of legislation, be it the state or the parliament. With authority means a valid authority considering the barring provisions of the Constitution of India. So it means that fundamental rights should not be obscured. The legislature should be competent to enact the act in terms of Part 11 of the Constitution of India. That is again your article 246 and 246A. And the other, it says the other articles of Constitution of India should be preserved. So basically what authority of law means is that there should be a valid authority in terms of the Constitution. There should not be any kind of restriction basis which this levy could be charged. So at the threshold itself, article 265 discards whatever the qualification a tax statutes might have. Okay, you, there may be a case that we often contend that a particular taxation statute is in violation of one or the other provision of the Constitution. When we say that this particular statute is in violation, say, of Article 14, it automatically jumps to the contention that it is also in violation of Article 265, because in a way Article 265 grant a valid authority of law. No tax should be imposed without the valid authority of law. Therefore, this Article 265 is a summary of all the constitutional exceptions provision basis which a taxation statute should be imposed. In a recent dispute before the Gujarat High Court in the case of Mohit Minerals versus Union of India, the Gujarat High Court has categorically uh, held that the levy imposed by the notification of under the IGST Act, under the garb of reverse charge mechanism notification on the CIF import, is basically not envisaged by the legislature, and in a way it is by imposing, by specifying a person to pay the tax on a particular transaction, they have made up it into a authority which is not provided by the legislation very specifically. Now, a question could be whether, of course, it also means a delegated legislation can neither impose tax nor provide for collection of taxes unless authorized by law. So, in the sense, a question could be arisen whether the new rule 96B of the CGST rules, which has been recently introduced and which seeks to extract tax if the goods which have been exported, if the corresponding convertible foreign exchange has not been collected against those exports. So the legislature, the CGST Act and the IGST Act do not provide any kind of receipt of foreign exchange in the definition of export of goods. So by introducing a different kind of an indirect provision in the garb of Rule 96B, in the garb of making rule making power, they have tried to impose tax on a transaction which is not which is not provided for taxation by the legislature itself. So it do appears to be that this rule 96B is in may fall vice of the article 265, in as much as the tax that is sought to be collected therein is not by the proper authority of law. um, there is another fundamental concept when we talk about Article 265, is that a taxes should not be collected without the proper authority of law. And at the same time, if any tax that has been declared unconstitutional, so it automatically becomes a tax that has been collected in violation of Article 265, and therefore it should be refunded uh, by the executing authority who happens to collect that tax. And also, in a very famous very famous case of Mafatlat Industries versus Union of India, the Supreme Court very categorically held that if there is any tax which is held to be declared unconstitutional, the tax should be refunded to the person from whom it has been collected, and there is no limitation period for granting the refund of these taxes, subject to the provisions of unjust enrichment. The unjust enrichment means that the person who is claiming the refund should not have passed the incidence of tax to any other person. In which case, the person who has ultimately borne the incidence of tax, will be eligible to claim the refund of these taxes. Another thing is that penalty that is usually imposed by the taxation statutes is also subject to the play of Article 265. It is not imposable by the delegated legislation. It is impossible only if the legislature has specifically provided for. So the Orient Fabric case is a very good judgment if one is to refer the authority on penalty under Article 265. And a parallel question in that regard could be asked from the point of view of the authority of National Anti-Profiteering Authority. Under Rule 127(3)(c) of the CGST rules, the authority has been empowered by the government to impose penalty wherever it finds the cases of profiteering. When we see this corresponding provision in the statute, section 171 only prescribe, the subsection 3 only prescribe that NAPA is the National Anti-Profiteering Authority would have the power to prescribe its own procedures and rules. However, it does not specifically says any kind of penalty in cases of profiteering. So probably this provision of Rule 127(3)(c) is also susceptible to challenge of being violation of Article 265. Now that said, that Article 265 is in it talks about the authority of law. There is another concept of component of tax. So a tax, it has been very uniquely identified by various codes that you say that there is a tax, but that tax should satisfy four main features for it being called a valid tax. In the sense that it should have an proper object of tax, that is, the tax should have a taxable event. It should be very specifically provided as to the what is the taxable event. Then the measure of the tax should be available, that is the value that is being circumscribed for the purpose of tax should be very specifically provided. Then a tax should identify the taxable person, that is, it must be there that who is the person responsible for the collection of taxes. And at the end of the day, taxable rates should be also be provided for in the charging section or otherwise. So these four components of tax should also be satisfied. A remarkable case in the case of Govind Saran and Ganga Saran versus CST is a landmark ruling in this regard. Now, when we go deeper into the four concepts and focus our attention into the valuation concept, in a one particular case of ASIN, okay, before that, I'll set a brief background. The first two features, object of tax and measure of tax, should be there, and it has been held by the Honorable Supreme Court in Bombay Tire International that these two should have a reasonable nexus with them. But once the reasonable nexus is established, it is not necessary that measure of tax would be equivalent to or justifiable or referable at all to the taxable event. That is, in the sense that when it when a tax is imposed on the manufacturing duty, and the value is the price of the wholesale price or the transaction value. This price of sale value is has reasonable nexus with the manufacturing price. Now, once that reasonable nexus is established, the revenue can add or delete some components into the measure of tax. There should not be any violation of it. There should not be problem with it. Another judgment in the case of Acer India, it was a customs ruling. The Supreme Court had observed that the measure of tax and object of tax should be such that the measure of tax should not take into uh, take into account any non-dutable item into the dutable item, such that the non-dutable item which is exempted from tax started becoming taxable in an indirect way. So, if I give you an example, there is a computer and there is a software. The computer is liable to be taxed at 18%, while the software is exempt from GST. Now, if uh, there is very categorically announcement by the government that they are not intending to tax software as such, and they have provided exempted rate. They have in fact provided exemption to it. Now, by some provision or the other, the executive cannot try to impose that. I'm so sorry. So the executive cannot bring into that non-dutable item, which is software, into the value of the computer so as to tax it in an indirect way. Now, this Acer India concept was put before a larger bench in the case of Grasim Industries, and the Supreme Court in Grasim Industries held this law as a valid law to the extent of non-dutable items. Now, when I see this concept that is there in this Acer India, and I compare it with the concept of mixed supply, so mixed supply in an indirect way tries to when an unnatural bundling of goods and services is combined together, and one of the element of it is exempted from the GST. However, by virtue of the mixed supply under section 8 of the CGST Act, that non-dutable items is also just exposed to the tax by virtue of this provision. So probably this mixed supply concept is in conflict with the ruling in Acer India. Then we have often faced dispute as to the taxable rate, whether it can be provided by the uh, central government in its rule making authority or otherwise. In a remarkable case of Pandit Banarsi Das, one second, I may have to recall that judgment. Pandit Banarsi Das Bhanot was a state of MP 1959 SCR. It was held by the Supreme Court that the rate of tax can be provided by the executive once a policy guidelines is provided under the act. So there is an often debate that the rate of taxes on goods and supplies is not provided by the CGST Act itself, but they are being driven from the notification issued by the central government. So if we are to refer to, if we are strictly applied this judgment, probably this challenge might not survive. Another thing about Article 265 is that where the rate of tax is not stipulated or it cannot be applied with precision, it is difficult to impose a tax thereon. It was held by the Supreme Court in the case of CIT versus Vatika Township. Now we have an entry 453 of Schedule 3, wherein this Schedule 3 of the rate notification of the goods, that is notification number 1 of 2017, wherein they say any other chapter. So in the place of HSN and customs tariff code, they have referred to as any other chapter. There could be multiple kind of categories which are not at all covered by, which may not be covered by any of the chapter. So could you still call them that this entry 453 is applicable on those goods? Probably not, but we have to see the day of light of the code in this regard. So one particular example I was able to come across was the scrap of this HT cables and LT cables. This scrap of HT cables and LT cables does not appear to be covered by any specific chapter in the central in the customs tariff code. So it would be debatable whether those particular scraps could be covered by entry 453 or not. Naveen sir, we have concluded
Yeah.
some slides on to Article 265, so you're
Yes.
requested to provide your comment.
Yeah. Are you able to hear me, Manish?
Yes, sir. Yes, sir. We are able to hear
Okay.
you.
Sir, you are audible.
Yeah. If you look at the Constitution as such, when you read the Constitution, actually we are reading our lives. Constitution talks about preamble. In fact, the expression "we the people" comes from the preamble of the Constitution, and preamble has been interpreted by the Supreme Court in Keshavananda Bharati's case, stating that it contains the basic structure of the Constitution.
Right. Right, sir. Right, sir.
If you look at the amendments made, there are a lot of amendments which are made which may affect the basic structure of the Constitution. For example, one of the basic structure of the Constitution is the power of the legislature to make laws. So if you have been observing in GST law, they have this GST Council, which is also created under the GST law, and they have in fact, every decision of GST, whether it is the rate of tax or what are the taxes to be subsumed, model law, exemption, special category states, what will be the tax, everything is determined by the GST Council. So the question may come that, in fact, I'm not seeing any debate at all on GST in the parliament or the state legislature. They are just passing the law as recommended by the GST Council. A question may come whether the GST law itself, by creating this new extra constitutional body, has taken away the power of legislature. This is something which should probably come in at least after we exhaust all the current issues, they may make up this in some matter. Then if you look at the Constitution, you have the fundamental rights, you have the fundamental duties, there are directive principles of state policy, which are only recommendatory and not mandatory. And you have this seventh schedule, which contains three lists, list 1, list 2, and list 3. The earlier setup in the past regime was not sufficient to take care of legislation like GST, where we wanted to impose simultaneous levy by the state and center. So we had to bring in some amendments. We'll see those amendments a little later. And if you, in fact, I always say this in some jurisdiction, foreign jurisdiction, fundamental duties also include the duty to pay taxes in some jurisdictions. So if I always say this, if you take care of the fundamental duties, the rights of others are all automatically taken care. Coming to few things which Manish was referring, Article 265 says that you cannot collect something with, and suppose somebody collects, if some government imposes a tax without the authority of law, what is the remedy available? The remedy available to the taxpayer is to challenge it by way of a writ petition before the High Court, and or if your fundamental rights are affected, you can even directly go to the Supreme Court under Article 32. Manish was referring to this Shirur Mutt's case while explaining the difference between tax and fee. Shirur Mutt judgment was rendered by the Supreme Court's judge bench, whereas in a recent judgment, which is 2017 judgment in Jindal Stainless Limited, the Supreme Court, comprising of 9 judges, again went into various aspects whether the tax is compensatory in nature. In that context, they again expounded the difference between tax and fee, and by and large, they agreed with the views expressed by the 7 judge bench in Shirur Mutt's case. In fact, these two judgments will give you an idea of what is a tax and what is a fee. As far as cess is concerned, He was referring to this Mohit Mandel's case. In fact, Article 270 itself uh, explains what is the nature of cess. And cess is something which is in the nature of a levy for a specific purpose. Contrast this with a surcharge. Article 271 would refer to surcharge as an increase in duty or tax. So there's a difference between cess and surcharge which we need to understand. And he was also referring to the provisions relating to this residuary entry in Schedule 3. In fact, if you go back in the central excise tariff before the 1985 tariff was issued, you had a residuary chapter. All any other item would fall under that residuary chapter. So the same logic has been adopted in GST also. And in a case where your goods don't fall under any particular item, then they would adopt the Schedule 3 and apply the residuary entry. Then, as regards the power to tax, he was referring to the judgment of Govind Gangadharan case. There, he was emphasizing the fact that can you mute the mic, Arjun? There's some disturbance. Hello.
Yes, sir, you can continue. I am mute.
Yeah. When it comes to this taxable person, the law also should define the taxable person. In fact, we had instances where the law had not defined it and the matter ended up in the courts. To give one example, initially, if you remember, in the context of service tax, goods transport agent was sought to be taxed by way of reverse charge. That means the recipient of tax has to pay tax. So, in this context, the Supreme Court in Laghu Udyog Bharati's case held that the rule cannot override the act, and they had actually quashed the levy itself, saying that you cannot tax the recipient. Then, giving one more example is in the context of reverse charge, that is, services received from foreign service providers. The government wanted to tax it through rule mechanism. They failed miserably because Section 68 did not enable as it stood at the relevant point of time, did not enable the delegate or the central government to make the recipient liable to tax. That mechanism was brought in by virtue of Section 66A of the Finance Act 1994, which was a prospective amendment, and this was also observed in Indian National Shipowners case. Then coming to certain other aspects, like Manish was referring to Rule 96B, where they are indirectly bringing in some concept of realization of foreign exchange even for the exporter of goods. For export of service, there is a specific condition that there should be realization also. But the export definition, either in the customs law or the GST law, does not talk about realization of foreign exchange. So this 96B, I'm sure, would be subjected to challenge in some court in the near future, because the tail is trying to wag the dog, which is not possible under law. Then the last thing which I would refer to here is Article 246A itself, which Manish was referring. In fact, he has also kept some more slides. Article 246 was required because the setup earlier regime did not enable a Jugalbandi tax by the state and center, where simultaneous levy of GST by the state and center could not be possible because the different taxes were in different lists, and there was no common platform. available for the legislature to attempt GST. Therefore, Article 246A was required. Over to Manish for the other slides. Arjun?
Yes, sir. Manish is facing little technical issues. By 2 minutes, we
Okay.
will resume.
Yeah.
I request participants to bear patience because of the issue. We will be resumed by 2 minutes.
Okay. Before he joins, I can probably add one or two important points.
Yes, sir.
Under Article 265, which talks about the power to tax, that is, you cannot collect something without the authority of law. Suppose the delegated legislation tries to impose a tax which is not authorized in the act, that can also be subjected to it can be questioned before the court, and it can be challenged before the High Court by filing a writ petition. A few more things about fundamental rights. When can you challenge a provision? We always hear this expression, unconstitutional, which we come across when we read judgments. If you suppose there is uh, some judgment which let us say there is some provision in the law which goes against the fundamental rights, you can always challenge those provisions as unconstitutional before the High Court. In fact, there are many such instances which are possible in the context of GST also. For example, in the garb of business, they have defined that expression in a very wide manner, which may give rise to issues where religious activities may be indirectly taxed, saying that whether you have pecuniary benefit or not, I'm going to tax it. So these issues may land up in the High Court. Manish, have you come back?
Yes, sir. He is there.
Yeah, please go ahead.
You can take it over to the next issue. Yeah, Manish, you can proceed on.
Is he muted, Arjun?
No, sir, he is not muted. He is trying to speak. His audio issue is there. 2 minutes, sir. He
Okay.
will be continuing. Manish?
Hello, am I audible now? Arjun, can you
You're audible.
hear
Yeah,
well?
you're audible. You can continue.
Okay. Okay. I'm so sorry for the connection loss. Can you allow me to share the PPT?
Yeah, sure. Just a minute. Yeah,
Yeah,
you
I'm
can
doing
share
that.
now.
Yeah. It's visible now?
Yeah, it's visible.
Okay. So I'm so sorry for the connection loss, and thank you, Naveen sir, for the rich value addition on Article 265. Then we quickly move to the territorial nexus, which the Constitution provide under Article 245. So Article 245 is one says that Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may may make laws for the whole or any part of the state. So there is a clear bifurcation between parliament and the state, that law can be made by parliament for the entirety of India, while a state can make law for the entire state. Now, second, the clause 2 is very important in this territorial nexus concept, is that it says no laws made by parliament shall be deemed to be invalid on the ground that it would have an extraterritorial operation. Now, it has a very unique feature that a law may be made by a parliament or a state legislature, which may have may be trying to tax the taxable subjects which have been within the jurisdiction of India, or as the case may be state, but the laws may have some extraterritorial operation, in the sense of some collection, in the sense of some recovery, or otherwise also. So this Article 245(2) was came into good scrutiny before the Honorable Supreme Court five-member bench in the case of Bengal Immunity Company Limited, and it was observed by the Honorable Supreme Court that extraterritorial aspect appearing in clause 2 has two connotations. One, it refers to law in respect of acts or events which take place inside the state but have operation outside India. And the second is that law with reference to nationals of a state in respect of their acts outside India. So it basically says that Article 245 says extraterritorial operations are only those second kind of categories and should be interpreted in that rigid sense. So basically, it basically highlighted as to what act can be saved by Article 245(2), in the sense that an income tax of India is a charges tax on the income arising out of in India. But it may be the case that sometimes that a person who has been residing in India is not available in India. So Income Tax Act has incorporated provisions to extract, to recover that money from the person who is stated outside India, the tax which has been fruitfully borne by the Indian continent. So basically, the act is not extraterritorial in its entire sense, because it intends to tax only the taxable events that have a nexus with India. It only has made certain provisions of the act extraterritorial in operation so as to achieve the purpose of the Income Tax Act. Compare it with a case where in indirect tax there could be taxable events which are either based on the origination of the sale or the service or the supply, or it could be based on the destination of a sale or a service or a supply. The Bengal Immunity Company Limited held that the second clause of Article 245 may not be applicable to those cases where this taxable event of sale or service are not covered by the legislature while defining their act. The the case of the concept of Article 245(2) was came into further scrutiny in another five-member bench in the case of GVK Industries Limited. In this case, the Supreme Court held that the Parliament is empowered to make laws with respect to aspects or causes that occur, arise, or exist, or may be expected to do so within the territory of India, and also with respect to territorial aspects or causes that have an impact or nexus with India. So, in this case, the Supreme Court somewhat increased the scope of Article 245(2) in the sense that it now also intends to cover the aspects, extraterritorial aspects that have occurred in the outside the territory of India, but subject to the condition they have a reasonable nexus with the Indian territory. So earlier, as per the Bengal immunity case, there might have been a case that when a sale was or when a supply was consumed outside India, as per Bengal immunity case, that Indian government would not have the power to collect tax on those supplies, because these extraterritorial operation was limited only to the extent of recovery and otherwise. While if we refer to this GVK Industries Limited's case, it is in contradiction to Bengal immunity case, because it says now that aspects that have occurred extraterritorial but because they have reasonable nexus with India. So, for example, an Indian person who makes a supply outside India to a person outside India. Now, because that person is an Indian national, is an Indian citizen, does it give the nexus, required nexus, and then therefore the authority of Indian government to tax the supply that has been concluded outside India? So, probably in this count, this GVK Industries and Bengal immunity cases have been somewhat contradictory to each other. And because both of these judgments are five-member bench, there might be a case in future to resolve the conflict between these two. In another, and obviously in the GVK Industries case, the Supreme Court did not consider the Bengal immunity case. So it might be the case that the case might be held to be the per incurium or otherwise, because the Bengal immunity had very categorically laid down certain aspects with respect to extraterritorial operations. In Electronic Corporation of India Limited versus CIT, it was held by the Supreme Court that a parliament statute having an extraterritorial operation cannot be ruled out from the contemplation of Article 245(2). While enforcement of law is not contemplated in foreign state, the state can enforce the law to the degree that is permissible with the machinery available to them, and such laws would not be extraterritorially invalid. So it says that there is a proper leeway available to a legislature when it makes a law. So merely because a law which has some extraterritorial operations, it does not ipso facto would make the law invalid on the count of Article 245(1). In a very good judgment in the case of Popatlal Shah versus State of Madras that relates to pre-constitution regime, the sales tax case of Madras general sales tax was in dispute, and Madras general sales tax Act had tried to couch the sales, every aspect of sales, which is the origination, the consumption, the place where the contract has been executed, in the definition of sales. So the SSE came forward that since the sale of goods has not been concluded in the state of Madras, therefore the state of Madras does not have the authority to impose tax on the sales. The Supreme Court, while upholding the validity of the Madras General Sales Tax, held that so long as the legislature is able to define the taxable event, and that event covers all the aspects that are usually seen in the taxable event, so as to say that a sale of goods has multiple aspects. It has origination of sale, it has consumption of sale, it has the aspect of where the contracts have been concluded. So long as the legislature define all the aspects of this sales in the definition of sale in its taxation statute, every transaction which is covered within that sale taxable event would be liable to tax under the taxation under the sale of goods act, tax on sale of goods act. So the principle following from this judgment is that so long as the taxable event is able to capture all those aspects relating to that event. So if I say that supply is taxable in India, so can I say that supply originated from in India is also taxable? Because the supply in India could be construed at whether the supply is concluded in India, or it could be said that the supply should be any aspect relating to supply, be it origination of supply or be it conclusion of supply. The supply event would be able to capture all those events. So the pertinent disputes sometimes arise in the context of an export of service transaction where the foreign convertible exchange is not received. So by the authority of IGST Act, the government of India has tried to impose tax on the transaction of export of services where the convertible foreign exchange is not received. So probably this aspect would have to be examined from the concept of extraterritorial operation as to whether uh, this attempt to tax this kind of transaction is saved by Article 245 or not. In a pertinent case of Mohit Minerals versus Union of India, which has been recently held, It was held by Gujarat High Court that the supply of service of transportation of goods by a person in non-taxable territory to another person in non-taxable territory from a place outside India up to the custom station of clearance in India is neither in interstate supply nor in intrastate supply. Therefore, the tax cannot be levied and collected from the Indian importers. So the Gujarat High Court, in a sense, applied the concept of Bengal immunity, and it says that this when a supply is concluded outside India, so therefore, be it having some nexus with India, there cannot be an authority to levy tax because this taxable event does not take place in India. And of course, we had a pertinent question of a case where the services are rendered outside India, its place of supply is outside India, then whether a tax can be imposed if one of the condition of export of services, say the receipt of foreign convertible exchange, is not satisfied. So whether this the contemplation of taxing this particular transaction is within the purview of Article 245 1 or not is a case to be seen. Naveen sir, if you could add anything on this, sir.
Yes, Manish. Thank you. If you look at Article 245, it says the extent of laws made by the Parliament and by the legislature of the state. So does it mean just because 245(2) says no law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation? Does it give the Parliament an unbridled power to, let us say in tax context, to impose taxes even on transactions which are taking place outside the taxable territory of India, is the question. And Mr. Manish was referring to the judgment of the Constitution bench in GVK Industries case. There are a couple of observations by the court which are also relevant in this context. The court said the Parliament does not have the power to legislate for any territory other than the territory of India. So within India, suppose they are exceeding the jurisdiction, territorial law, if the law extends to certain other territories, then there may be a case to invoke 245(2). And similarly, they said that if you are not able to establish a nexus with India, and extraterritorial aspects or causes are sought to be taxed, then it would be ultra vires, and it can be challenged before the court. So if you look at the service tax law, many issues cropped up in the past as to services received outside India, services provided outside India, performed outside India, rendered outside India, received outside India, consumed outside India, utilized outside India. Whether those type of transactions could be subjected to service tax was a big debate in the context of this erstwhile service tax law. There you would be finding some cases where the tribunal, in the case of Infosys, Tech Mahindra, then KPIT Cummins, Torrent Pharmaceuticals, then the one decision of Intas Pharmaceutical, perhaps the first decision on this point, saying that you cannot tax something under the service tax law, which a transaction which is happening outside the taxable territory. If you look at GST also, these issues may crop up because if you look at service tax law, the first provision itself would say this law applies to the whole of India except Jammu and Kashmir, whereas GST applies even to Jammu and Kashmir, given the present scenario. So questions may come. Let us say my employee goes outside India for a tour, business tour. He avails various services outside India. It may be travel agent, it may be taxi, hotel, whatever it is. Then he comes back to India, those expenses are reimbursed and booked in the company's account. Can you say that the reverse charge is applicable? Then one more thing, suppose I operate through branches. Let us say branch takes up some activity on behalf of the head office, which is in India. Can you say that the branch is providing services to the head office? In fact, Schedule 1, there is a problem. The last clause 4 says that an establishment outside India can be treated as providing services to the head office in India. But still, the question which is very important is, suppose those services are rendered outside India, can it be subjected to tax? Do we have the jurisdiction under the GST law to capture and tax transactions which are occurring outside the taxable territory of India? This is an issue. In fact, those tribunal decisions which I mentioned in service tax have been taken to the Supreme Court by the department. The batch matters are pending before Supreme Court. So once those decisions come, the same principle will also apply to the GST law. As of now, the tribunal decisions are in assessee's favor, saying that you cannot tax something which is happening outside India. Then one more Supreme Court judgment on this taxable territory is in the case of All India Federation of Tax Practitioners, where the Supreme Court explained the nature of service tax. They said it is a destination-based consumption tax and it is applicable on transactions which are happening within India, services which are happening within India. So even GST is a destination-based consumption tax. That principle expounded by the Supreme Court in AFTP's case would equally apply here also. Then when it comes to uh, this extraterritorial operation of the law, you will find when you go to this place of supply, you would have already seen when you did the basic course, and even in the context of in this advanced course which you are doing, the place of supply related provisions which are envisaged in the IGST law gives an impression that it is sought to be applied even to territories outside India. For example, there may be something related to, let us say, uh, let us say a case where there are two parties who are in India. Uh, Let us say it is the airline and a person who services the airline. These two persons are registered in India. The airline operates across the world. The aircraft lands in some other place. Let us say in Singapore, there is a fault. The Indian service provider goes and services it there. The service is clearly happening outside in India. But since these two parties are from India, the department is likely to apply the place of supply provisions and say, I would ignore the place where it is happening. Since you both are from India, I would subject it to tax. So these type of issues may crop up, which would result in litigation. And Manish was also referring to the Delhi High Court judgment in the tour operators case, which is also an important judgment. And finally, on this extraterritorial operation, he was saying that if referring to Mohit Mandals, he was expounding the transactions where the sale happens in different territories, not in India. It is known as merchant trading. For example, my goods are in Singapore. I sell to my customer in Japan. Just because I have a company in India, it cannot be subjected to tax under GST. In fact, there was confusion in the beginning, and Schedule 3 was amended in 2018 to make it clear that it is not in the nature of a supply. Similarly, high sea sale transactions also, where it is when the goods are not even reach the territorial waters, I'm indulging in high sea sales. Can it be subjected to tax? That is also made part of this Schedule 3 by virtue of the 2018 amendment. So this territorial operation of law is something which becomes very important, particularly in service context, because services are intangible in nature as compared to goods where you have clearly defined principles under the customs law or the GST law. Over to Manish.
Very well, sir. Thank you. I think the distinction between the place of supply as proxy and their characteristics as authority to tax is very well made out there by you, sir. Thank you, sir. So next is a very crucial topic is to legislative competence. And as we all know, there is a Article 246 which provides the fields of legislation for Parliament and state legislature. And then we have Article 246A, which provides special provisions with respect to goods and service tax and enables the Parliament and state legislature to make laws with respect to imposition of tax. I will straight away jump as to what is the uh, relationship between Article 246A and 246 in the sense that whether either of these two articles overlap each other or not. So if you could see, there is some analogical both of these articles do not explicitly say that with which of these two would preside would over the other or not, but we have some anthological evidence where we could expound as to which is the primary source and which aspects Article 246A tends to cover and what all leaves it for the 246. So entry 96 in the list 1 prescribes that the residuary power of the union government. Now, if you could see, entry 97 is traceable to Article 248 of the Constitution, which says that Parliament will have residuary powers to enact tax which are not on the aspects that are not provided in list 2 and list 3. So in a landmark case of Union of India versus Harbhajan Singh Dhillon, it was held that Article 9, NT 97A is traceable to Article 48, and Article 248 in essence is the residuary power to impose tax. So there was amendment in Article 248 by the 101st Constitutional Amendment Act, wherein it was made subject to Article 246A. So an analogy could be drawn from it that the residuary power of the union government is made subject to Article 246A, in a sense that so long as any aspect is covered by 246A, the union government cannot make law with respect to that particular aspect under Article 248 read with into 97. So it gives an indication that Article 246 is the prime source of taxation when it comes to the aspects relating to GST, and any aspect that has a connection with the supply, which includes the interior forms in the form of sale, services, sale, transfer, barter, exchange, etc. Those should not be covered by Article 248, or for that matter 246, Article 246 also. In a sense that if we read combined 246 and 246A, it could be said that Article 246A abrogates Article 246 to the extent it covers supplies of goods and services, and therefore this is the reason also that it makes entry 54 of the state list and entry 92A workable. Because if you see, if we are to apply 94, if we were to assume that the states still have the power to levy tax on sale of goods, and the center would still have the power to levy tax on the interstate sale of goods under entry 92A of the union list, then those uh, amended form of these entries 54 and 92A would be rendered meaningless because they were there for a certain purposes, and therefore it can be said that to the extent that these entries have been amended and being subsumed in Article 246A vis-a-vis GST, the Article 246 do not contain power to do not enable the state legislature and the parliament to tax a particular tax on the sale of goods. However, there is a possible conflict when we say that say that the Article 246 A abrogates Article 246 Article 246, because when it comes to the electricity tax is covered by entry 53 of the list 2. Earlier, before this amendment in entries 52, 53, 54, and 92A of respective lists, the power of state to impose tax on sale of goods was limited by Article 286, which says that a state cannot impose tax on interstate sale of goods. Now, entry 53 and entry 54 did not inherently had any kind of restriction within themselves that these taxes would be leviable to only intrastate sale of goods. However, this restriction drew from Article 286 of the Constitution. Now that this Article 286 has been, the words in Article 286 have been, the words of sale in Article 286 have been replaced by supply. So it kind of gives an indication that Article 286 is only applicable on the aspects covered by Article 246A. Now, in that sense, although entry 54, which has been amended to insert the words intrastate supplies of goods, that suffice the relevance that Article 246A is supreme over Article 246. However, when we see entry 53, which is tax on the sale and consumption of electricity duty, it is still not been amended, and the entry still remains as it is. So therefore, unless Article 286 is implied or enforced upon entry 53 of the list 2, the state would have all the ample powers to enact electricity duty on the sale of interstate sale of electricity of interstate sale of electricity as well. So unless Article 286 is applied with respect to Article 246 46 also, this entry 53 would have some far-fetching event. Now we can say that there is a possible substance that even though Article 246A with respect to supply has abrogated the power under the Article 246, but however, with respect to some lacuna flowing from other constitutional provision, there could be still argument so as to, the object was to save the Under 53 from being unconstitutional. There could be an argument, although that there is some overlap between Article 246 and 246A. Uh, there is another point of dispute between Article 246A in the sense that whether the state can legislate on aspect covered by the erstwhile and unamended entry 54 of the list 2, which was sale of goods by the persons in the course of intrastate sales of goods. So whether a question could be whether a state could fragment the concept of supply into different forms and therefore try to impose a sales tax of its own on the interstate supply of tax. How now there are, again, there is a positive view and a negative view that there are analogy flowing from the constitutional provision that state cannot fragment the supply into sales and services. Once there is a supply, the tax has to be levied under Article 246A and not otherwise. So if you could see, there is as I explained, this Article 286, which has replaced the word sale with supply. So it gives an indication that any taxes which a state could levy is only under Article 246A on the sale of goods. And because if Article 286, which has replaced the word sale with supply, if Article 286 is still rendered applicable, it would have been difficult for the Constitution to restrict the power of state to tax the sales. So what I'm saying is that Article 286 has to take effect. And unless the supply event is taken as a whole, Article 286 would not be taken into effect if the state is empowered to impose tax on the sale of goods, because they cannot bifurcate from Article 246A, a component of supply. There is another analogy flowing from the definition provided under Article 366(12) 12A, which says law with respect to goods and service tax, which is tax on supply of goods or services. So the GST says any tax on supply of goods or service tax. It does not bifurcate between the elements of supply. So you cannot say that supply means all taxable forms which might incorporate therein. That could be include sales, services, transfer, barter, exchange. So when the constitution say that there is a nomen juris words of supply, it cannot be bifurcated. Then of course I have explained the controversy with respect to electricity tax. So unless electricity duty under entry 53 is read with article 286, 286, it would have been difficult for the it gives an indication that unless entry 53 is read into article 286, the state would be having overarching power to impose tax on interstate sale of electricity duty. So there is a controversy flowing whether article 246A can be fragmented to impose to enable states to levy tax or not. In a recent case of Reliance Industries, the Gujarat High Court has held that a state cannot bifurcate the element of supply, and therefore any tax on sale of goods would be through article 246A only. And in fact, in Mohit Minerals case also, the Supreme Court had held that goods and service tax include GST as well as any other tax in the nature of GST on the supply of goods. So therefore, it also gives an impression that all the taxes going forward should be imposed as a supply, and no other event could be extracted out from Article 246 of the Constitution. There is another element as to interplay of Article 246A with other constitutional provisions. So, as I said, that there is a concept of GST Council under Article 279A of the Constitution. So, any tax that is implemented under Article 246A, whether it is subject to the valid recommendation by the GST Council, in a sense that GST Council should have made recommendation as to legislating a tax on the supply of goods. Unless that recommendation is made, a tax, the legislature is bad in law. So in the Reliance Industries case, the Gujarat High Court had held that the state do not have inherent power to impose tax under 246A. It is subject to the other constitutional provisions such as Article 279A, 269A, 286 of the Constitution. So therefore, whether this recommendation power of GST Council could be said that unless a recommendation is made, legislature cannot impose tax on certain supplies. So since the a controversy could be the case that although the Kerala government had been allowed the recommendation from the GST Council to impose Kerala flood cess, but it is only within the limited time period of 2 years. So, say if after 2 years this period is not extended by the recommendation of GST Council, it could be susceptible to challenge that since there was no recommendation of GST Council, the tax in the name of Kerala flood cess should no longer suffice. Then we have Article 253, which is notwithstanding to any other provision of this chapter, and this article honors the international agreement that the India had entered with other countries. So suppose if there is any supply that is made to international financial institution like ADB or IDB, there is a power flowing from Article 253 that notwithstanding anything, the tax cannot be imposed on these on the supply to these institutions. And in fact, this aspect has been clarified by one recent circular also. The other possible aspects related to legislative competence is that it has been widely interpreted by the courts that legislative competence power should be interpreted in the widest possible manner. Then this legislative competence should be seen on the date on which this power has been exercised. Then there is another argument that that a legislature which has power to which has legislative competence to make law, it also has the power to make it retrospective. Now, when I say that there is a retrospective power to impose tax, there is another concept of retroactive legislation. Now, in US and Canadian jurisprudence, there is enough evidence that although a retrospective amendment is permissible, however, a retroactive amendment, which basically changes the facts from a backward date, is not permissible. So, when I say this retroactive legislation validity, there could be a case that when this judgment in AAP and company was declared, and after that uh, the government had retrospectively amended Rule 61 of the CGST rules, where they have said that the return in GSTR 3B shall be deemed to be a return under Section 39 of the CGST Act. This just changing of facts that this particular return is a return from the backward date. It does appears to be that it is a retroactive legislation and it could be susceptible to such challenge. So I pass on the forum to Naveen sir for his comments.
Thank you, Manish. As far as Article 246 is concerned, we should read Article 246 along with 7th schedule of the Constitution, which talks about those three lists which I mentioned: union list, state list, and concurrent list. Now, why 246A was brought specifically was to empower the state and center to simultaneously levy GST on intrastate transactions, intrastate supplies, and the parliament has the exclusive powers to tax interstate supplies. That is the effect of 246A. But if you observe, as Manish also pointed out, 246A starts with a non-obstante clause, that is notwithstanding. It overrides 246, and by virtue of which the power to impose tax need not be traced to 7th schedule any longer. Impose GST you need not go to 7th schedule to see whether I have the powers, but it is conferred under 246A itself. That is the effect of 246A. It facilitates imposition of GST. As far as the residuary entry is concerned, entry 97 of the first schedule, the 7th schedule, list 1, where Article 248 talks about it. Even Article 248 has been made subject to 246A. So the question is, can I impose any new tax using the residuary entry on the same taxable event, which is supply of goods or services or both? In my humble view, you cannot bring in any new tax in addition to GST on the same taxable event, because what is authorized under 246A is only a tax in the nature of GST, and you cannot include additional things, despite what the court has said in Mohit Mandel's case. I think it may be open to review in future. Coming to the residuary powers, you take the service tax law. Service tax law, you cannot trace it to any of the entries in list 1 of schedule 7. It was imposed under entry 97 only. Although they had introduced entry 92C, it was never made operational. And the 101st Amendment has in fact omitted that particular entry. So service tax law is one example of a huge legislation which was enacted only because of the residuary power which the parliament has. But one thing which entry 97 mentions is that it should not be falling under the state subject. If you look at entry 97, it is very clear in saying that the parliament cannot encroach upon something which is the states within the state's power. So therefore, if you see some of the case laws which have emerged in the context of service tax and VAT, questions have come whether VAT is applicable or service tax. Wherever jurisdiction has been exercised by the VAT department and taxed, the courts have generally held that service tax cannot be imposed. It may be a case relating to right to transfer of right to use goods which are subjected to VAT, and there was supply of tangible goods which the union wanted to tax under the service tax law. Similarly, software which was considered as goods and taxed under VAT, and the service tax department would also try to impose tax on the same activity. You see the judgment of the the Karnataka High Court in Infosys case on this aspect, which is now pending in the Supreme Court. There is also a concept of rag bag legislation, which is very important in the context of upholding the constitutionality. So when you trace the powers, you need not restrict yourself to only one entry. The entries which are there in the list 1, 2, and 3 are only fields of legislation, and therefore I can draw support from more than one entry to sustain a levy. That is known as the rag bag legislation, which is also discussed by the Supreme Court in Ujagar Prince case. Then another important aspect is by virtue of entry 97, can they keep imposing cess like this compensation cess or COVID cess, which is expected in some jurisdiction? In my view, this residuary entry has been made subject to 246A. If you want to exercise powers under entry 97, the parliament can do so, but it cannot be again on the taxable event of supply of goods or services, is what I understand from a plain reading of 246A and related provisions. Of course, these issues may crop up in future also, and the Supreme Court would would ultimately lay down the law. Coming to electricity tax, a basic question occurs as to whether electricity tax can be sustained. Is it valid now, given the fact that GST has been imposed on sale or any supply? Because if you look at one judgment of the Supreme Court in G.R.G. Rao Cotton Mills Limited versus State of Madhya Pradesh, it is a 1962 judgment where the power to impose electricity tax was challenged, saying that it was in conflict with entry 84 of the list 1, which dealt with this manufacture. That is the entry under which excise levy was imposed by the center. There, the Supreme Court made an observation that the tax under that legislation which was challenged would apply when the person sells the electricity or consumes it, and they are not on not when he produces it or generates it. So therefore, they said that uh, there is no tax on production as such. So that judgment is worth reading in this context also. Now that they have subsumed all the taxes, and supply also includes sale. So can you still sustain the electricity tax is the question which may arise. So and particularly when electricity is subjected to nil tax under the GST law. Once you say that it is exempt or subjected to nil tax, that means they are recognizing the fact that it attracts the levy of GST. Therefore, they want to give an exemption. So these are some of the observations which I had. Over to Manish for the other slides.
Yeah, thank you, sir.
Sir,
Arjun,
yes, sir.
I think
Thank you.
it's
Manish,
11 o'clock.
Yes, sir. Yeah,
Manish,
can we go for first part of Q&A, sir, so that we can postpone the next part to second part of session.
yeah, Arjun, one point which I wanted to touch upon before we open up for questions. Manish was referring to this power to make retrospective amendments. In fact, many times what happens, you contest a particular matter for years, and the Supreme Court renders a judgment, and immediately it is overcome by a retrospective amendment, which we have witnessed in GST itself. In fact, in 2014, the government said that there is no more tax terrorism, and that retrospective amendment amounts to tax terrorism. That was the view expressed. And now, if you keep looking at the latest recent trends, there are retrospective amendments in GST law. One was to overcome that UP decision, where the court said GST R3B is not a return at all. But then, by virtue of a rule, that too retrospectively, they try to say that it is in the nature of a return. The second thing which we have witnessed is in the context of Section 140, the transition credits, where there was no time limit prescribed for availing the credit, but by virtue of this Tran 1 form, etc., Rule 117 prescribed a time limit, which was challenged before the court, saying that rule cannot override the act. Decision came. Now, by virtue of a retrospective amendment in 2020, they introduce a time limit. Now, what is the position of law? Whether the legislature can bring in a retrospective amendment? Power to legislate or power to impose tax also includes power to amend. And this power to amend also includes bringing a retrospective amendment. But only thing which they have to do is they have to overcome the defect or the lacunae which is pointed out by the court, which resulted in quashing of that particular provision. That is the test which has to be applied. You go back to service tax law. This audit provision was not there in the act. Under the act, only a professional like a cost accountant or a CA could do audit for the department. But through rules, Rule 5A talked about it, and they wanted to conduct audit. Departmental officers wanted to conduct audit. It was challenged twice before the Delhi High Court. The Delhi High Court quashed it twice, but still they tried to tinker with the provisions and without overcoming the defects pointed out. So we have seen such instances in the past. And one thing about retrospective amendment is the rules can never be amended retrospectively so as to take away vested rights, as done in the or to impose new obligation like GSTR 3B, whether it is a return or not. So I am sure that is going to be discussed by the Supreme Court also. So I think we can take questions before the break.
Yes, sir. Thank you, Navees,
Yeah.
for your input. Now we can go for Q&A session for the first part of the session. Manish, I would be reading the questions for your easy reference so that you can answer, and after that, Naveen sir can add up if anything required.
Sure. Okay.
Okay. The first question related to the session. Based on which concept or can we borrow the principles of erstwhile regimes, which we have experienced for last 6 decades? Can we borrow the principles of erstwhile regimes into GST law? And can we borrow the principles of customs law, what the officers are following in relation to levy, refund, etc., assessment, etc.? Can we borrow such principles for the purpose of interpreting the GST law?
Okay. What we can think of in this case as to what at times an interpretation of a definition could come into question, an interpretation of the paraphrase or a sentence could come into question. So we have to see whether this similar definition was discussed in either the Customs Act or any other act that we want to borrow principles from. So we have to first see whether this act is cognate and agnate with the current act or not. So if I say, if you want to borrow the principle from the Service Tax Act into the GST, you could do so because the Service Tax Act and GST Act appears to be somewhat similar in the context. Similarly, many of the concept of Sale of Goods Act and the Excise Duty Act are also cognate with the GST Act. Probably in those cases when you treat the aspects as cognate and agnate, those principles could be borrowed into the interpretation of GST provision also. I have a little certain doubts as to how much extent we could borrow from the principle from the Customs Act, because Customs Act operates on a little different field from the VAT Act that we have today in the form of GST. So probably we could borrow principles relating to recovery and other mechanisms from the Customs Act, or for that matter any other act. But when it comes to the taxable event and measure in every first principle sections, it might be somewhere difficult to borrow the provision from the Customs Act. I leave it to Naveen sir if he has any other views.
Yeah, it's a very important question which the learned friend has asked, whether we can borrow the principles from the past regime, legal principles, or the legal principles expounded by the courts. Can we read it in the context of GST law? As Manish pointed out, we should be very careful. We cannot blindly bring some concept which was there in the old context and apply it directly to the GST law. For example, we have a lot of case law development under the VAT regime with respect to works contract. Can you apply those principles blindly under GST law? The answer would be no. The reason is you have a peculiar definition in the GST law, and works contract in GST law, section 2119, clause 119, restricts it to immovable property alone, unlike the earlier regime where it would apply to even movable property. So this concept of the composite supply or mixed supply has become relevant in respect of uh, movable property, and schedule 2 deals with classification. So therefore, I'm also reminded of the Supreme Court decision. Supreme Court has warned us long back, don't apply the precedents blindly. You cannot apply the precedent uh, like a Euclid theorem, is what the Supreme Court said in Al Nouri Tobacco's case. And therefore, we should always remember the legislation which we are reading, the particular context, the particular provision of law, the taxable event is now different, the concepts are different. So we should be extremely careful, but nothing prevents you from applying the legal principles if it suits the context. So we should be, that is left to the judgment of the person who reads it. And ultimately, if you are applying some principle and if a dispute crops up, it is for you to convince the court. Therefore, we should be aware of all these factors before we apply the legal principles. Yes,
Okay.
sir. Next.
Yeah.
Thank you.
So moving on to next query, this is relating to the extraterritorial jurisdiction. Sir, if you see presently in GST law, by bringing into the deeming fiction of place of supply, there are some of the transaction which GST tries to levy tax even though the transaction is happening outside India. For example, supplier and recipient are within India and the immovable property is located outside India, even though the service is actually provided by leasing out a property outside India, just because both the supplier and recipient are within India, the GST law provides the place of supply as location of recipient. Can we challenge this provision based on Article 245, which is contradicting regarding this extraterritorial jurisdiction.
Manish?
Naveen sir, you would like to answer? Okay, I'll give my comment, sir. So, if you see Article 245A, 245, it restricts the extraterritorial. It says the extraterritorial operation of the laws. But at the same time, we have another preamble article in the Constitution which says that any laws is should be made up for the territory of India only. So suppose if you are able to prove that any particular event that is sought to be taxes is is a circled around a particular aspect. So when we say a supply is circled around a destination, in OECD we have principles that the supply event should be seen from its destination point. We could very well say that when a supply is not happening in India, is not concluded in India, therefore tax should not be levied. And to answer your precise question, this place of supply, it is well settled in the European courts and the OECD guidelines that place of supplies are merely proxies to determine the taxable place of taxation. They cannot overarch the basic structure of the constitution or the basic provision in a statute. It cannot exceeds the jurisdiction that a taxation statute is supposed to exercise upon. So we can say that place of supply should be adhered only to the extent they are within the jurisdiction of India. They should not be assumed as if they are giving extraterritorial power to tax the supplies that have been concluded outside India, or they have the supply has necessarily been outside India. Hope I am able to
Yeah.
answer. Naveen sir, if you have
Yeah.
any comments on this, sir.
Yes. I think I also gave an example similar to what Arjun pointed out, where that airlines, my aircraft goes somewhere else, I go and repair it. Both the parties are from India, it is sought to be taxed. That is a clear case where they ignore the place of performance and go by the status of the residential status of persons. So actually, it appears to be arbitrary to me, and therefore it would be open to challenge. So I am sure that many such issues would crop up. And looking at the ratio laid down in GVK Industries case and the Delhi High Court in the tour operators case, it would be open to challenge.
Okay, sir.
Yes, sir.
Uh, Moving on to next query. Sir, this is a general query. It's not specific thing. Sir, if you see most of the constitutional validity wherever we are trying to challenge against the provisions of the law, the finality is attained only in the level of court, either in high courts or Supreme Court. So, to what extent, as a general practitioner, can we rely upon this constitutional validity challenges, where whether we can rely upon such context at that lower level of adjudicating authority, like till tribunal? Can we take a stand based on the constitutional aspects and argue to the adjudicating authority to pass an order? Uh,
Okay.
Manish?
Manish, would you like to answer?
Yes, sir. I would have some brief comments on this. I think very good question as to whether to how an extent we could put in the constitutional qualifications when it comes to deciding whether we should pay taxes or not, whether we should claim ITC or not. I think there is a very settled principles that a constitutional arbitrariness or constitutional
Hello, Manish.
constitutional qualifications can be challenged only before the High Court and Supreme Court. Am I audible?
Yeah,
Yeah, you are
Am I
audible.
audible?
Yeah,
Arjun, am I
yeah,
audible?
you are
please
audible.
go ahead.
Yeah, yeah.
Okay. So what I'm saying was, yeah, thank you. Okay, so what I was saying is that constitutional challenges are only acceptable before the High Courts and Supreme Court under the judicial review powers of these courts under Article 226, Article 32, and Article 141 of the Constitution. However, the tribunals, being a quasi-judicial authorities, are only authorized to interpret a law which has been framed by legislature. They cannot hold up any particular a challenge to a constitution in their purview. They do not, they cannot exercise jurisdiction to determine the constitutionality of a particular provision. So therefore, when we say that to and how extent we should be relying upon the constitutional qualification of a statute, I think what we should decide is that what first we should determine is that whether this situation is a revenue neutral for us. And if the situation is revenue neutral, it is better to not to go with any constitutional qualifications. You could always have the authority, you would always have the leeway to go for a refund just in case in future a constitutional court held a provision as unconstitutional. So this should be a hierarchy as to whether there is a revenue neutral position, whether this constitutional provision that I'm citing for my client is it that in substance is a very highly probable that provision is unconstitutional or maybe unlikely, maybe likely to be held unconstitutional. Based on this hierarchy, I think we should be deciding to place reliance upon the constitutional qualifications. um, that's my comment, sir. Naveen sir, if you have to
Yeah.
add anything.
Yeah. One example which I can cite in the context of service tax is whether club or association was liable to tax, and whether the mutuality principle would apply was an issue which has been agitated from 2005 onwards. I remember, if you go back and see some of the judgments, one judgment of Century Club, which was argued by my senior and myself, although you will not find my name in that judgment. There, probably that was the first judgment which went into this aspect. And of course, there was Calcutta High Court judgment also on this aspect. What we did in many of the matters was, uh, it is advisable to take that argument in your pleadings, although the authority would not like to go into that because he is a statutory creature and therefore cannot decide constitutional matters and under the constitution. They don't have powers. Even tribunal is a statutory creature. What we used to do was, we would take that argument in the pleadings, and as the matter went up to the tribunal stage, there were already high court judgments. In fact, Karnataka High Court was against. There were some judgments of the Calcutta High Court and this Ranchi Club. Then you had this Jharkhand High Court and Sports Club of Gujarat, where they said that because of mutuality principle, the club and members could not be subjected to tax. Then it went to Supreme Court, and we all saw the judgment of the Supreme Court, which in fact they decided both the VAT and also the service tax issue. They said that the constitutional amendment in 1982 was not sufficient to overcome the mutuality principle. They explain in so many words. So the point here is, it depends on the stakes also, and sometimes wherever there's an option, as Manish pointed out, to recover the tax and remit it to the government, that would be the best thing, because the financial impact also should be seen. After 25 years, suppose a judgment comes against the assessee, he would not be in a position to collect the taxes, particularly where the issues are contentious. So take those arguments and cross the bridge as it comes. And when some of the matters are reaching the tribunal now, and the moment you cite Calcutta High Club decision of Supreme Court, they just follow it and allow the appeal. So that is one of the strategies which one could adopt if you are not willing to lend your name for a celebrated decision.
Mhm.
Yes.
Okay. Sir, in addition to the same, can we take a stand like that? I have already challenged to the lower adjudicating authority. That means at the time of SCN, I have listed out all the constitutional validity challenges in my reply, and the
Mm,
authority has not accepted my grounds, and he has rejected and he has recovered the taxes from me, and I have not gone
mm,
for appeal. And in
mm.
future, like this kind of Supreme Court decision is been coming in favor of assessee, can I take a stand from the date of the such judgment? Can I take a stand? I have already challenged in my reply. So the decision should applicable to me also. I can apply for refund of such recovered tax. Can such ground can be taken by such assessees so that this
You
validity challenging in the lower adjudicating authority would be helpful for the assessee.
you will be hit by the ratio laid down in Flock India's case, where they said that if you don't challenge an order which is passed against you and leave it, then
Okay.
you cannot again recycle the issue and file a refund claim. So the law aids the vigilant. A person who does not want to contest cannot claim the benefit of some decision which comes 15 or 20 years later. So he should keep the issue alive by filing an appeal and take the benefit of any future judgment. He cannot say that I will not contest the matter, but if something comes, I will ask for refund. That will be difficult. The courts may not entertain. Even if he files a writ petition, they would not accept it because you cannot keep matters open forever.
Okay, sir. Okay. So moving on to next query, Manish. If you see Article 366(29)(a)(f), there the restaurant services has been classified as supply of sales. It's treated as sale of goods, whereas in GST Schedule 2 classify such restaurant sales as a services. Uh, what is your view on such contradiction?
Okay.
Is it
Since this aspect is to be discussed in our further proceedings, I'll probably leave the broader answer to when we come to that situation. But yes, I would say this: yes, Article 366 is to an extent is in conflict with Schedule 2. However, if you read the preamble of 366(29)(a), it says the following transaction shall be deemed to be the tax on sale of goods. So when I'm saying that these are tax on sale of goods, while on the other hand, I am classifying the classification of supply, which is a broader aspect. So with Article 366(29)(a), what I was doing was bifurcating a particular transaction between goods and services. While on the other hand, with Schedule 2, what I'm doing is providing a new color to the transaction itself. So there could be an argument or it could be a comment or remark that to an extent it is in contradiction to 3629 is in contradiction to Schedule 2. However, we have some changes in how we should be interpreting the word supplies. So supplies should be seen so when I'm classifying the restaurant services or similar terms under the article 366(29)(a), I should be seeing the classification of the supply itself rather than bifurcating the element from the supply transaction. Uh, Naveen sir, if you have a better answer.
See, when you look at the difference between the classification in Schedule 2 and Constitution, Constitution treats it as a deemed sale, whereas the Schedule 2 says restaurant service is in the nature of service only. It is a composite supply, and they say please treat it as long as there is no disparity in rates or in terms of exemption status, etc., there would not be a problem. But once there is some rate difference, then I'm sure that this issue would crop up, and it would be challenged before the court, saying that the Schedule 2 deeming fiction is against the constitutional deeming fiction. Now that the supply includes sale, So therefore, any tax on sale, the definition in Constitution would also apply, and therefore it would be interesting to note how the court looks at this matter. So as long as the rates, there is no problem. Exemption status, there is no problem. I don't see any issue. But once there are some differential rates or differential treatment in terms of exemption, this issue would crop up. Yes, sir.
And also, to an extent, the courts might try to save Article 369(29)(a), particularly the works contract entry, by saying that this works contract entry in subclause B of 29A is only restricted to the petroleum goods, because their petroleum goods are still not brought under the purview of GST. So they could say that some of these aspects are in Article 366(29)(a) are different from the purview of from the supply of goods that are covered in GST. To an extent, there could be an argument like this.
They may read it down.
Right, sir.
Doctrine of reading down can be applied. So it would be an interesting issue,
Right.
nevertheless. Yeah.
Right, sir. Yeah.
Arjun?
Moving on to next query. Yeah, moving on to next query, sir. Sir,
Yeah.
the next query is relating to the overriding effect of SEZ Act versus GST Act. So under SEZ Act, Section 51 says, notwithstanding anything provided in any of the law for the time being enforced, the provisions of SEZ Act will have a overriding effect over the other provisions. And presently, the GST law has been enacted through Article 246A and not through 246. And 246A itself overrides the base Article 246. So considering these two initial basic overriding effect of the GST law, can we take a stand that the SEZ Act will override only those laws which has been enacted under Article 246 and not under 246A? This issue came up because as per SEZ Act, SEZ is deemed to be a part outside India. However, GST is considering SEZ as within India in case of services. So just to resolve this contradiction, the query has been raised. Sir. Manish, can you deliberate first?
Yeah. So we have two kind of concepts that could be applied in this context. One is that a specific law overrides a general law. So when I say a SEZ Act is in place and it is a specific law to the SEZ, so it could be the argument that okay, the SEZ provisions in the as provided by in fact Section 51 of the SEZ Act also, these provisions that are specific to the SEZ would override all the acts, including the GST acts as we know it. On the other hand, there is another doctrine which says that when a later statute is provided and an earlier statute had not envisaged the effect of a future statute. So this later statute, in this case, since the SEZ Act was passed in 2005 and the IGST Act and CGST Act have been passed in 2017. So there could be an argument that since these acts have been provided later on, it have impliedly repealed those provisions of this SEZ Act which are in conflict with IGST Act. So there is a concept of implied repeal also. It would be interesting as to which way the court might go in, but there is a reasonable expectation that the specific over general law would preside over the implied repeal contention that any party may put in. Naveen sir, if you have you could provide your comments also sir on this.
Yeah, the question which the participant has asked can be a thesis question. You can do a PhD also on the interplay of 246A and 246. I'm just responding. In fact, it requires a lot of research to answer that and the reading of case law development also on what happens to such a law. And it is unique to GST because 246A has come for the first time. So this question itself is a beautiful question, but I am just looking at it in this manner. For the time being, this is my answer. and if I apply my mind, my answer may change. Therefore, the question is common, the answers may vary at different points of time. See, if you look at the powers conferred under 246A or 246, these come under part 11 of the Constitution, and it deals with the relations between the union and states. In fact, chapter 1 refers to legislative relationship between the state and center. Now, and to what extent laws can be made by Parliament and legislature is stated in Article 245. Then 246 says the subject matter of laws made by the Parliament and by the legislature of the states. Now, if you look at uh, suppose I exercise the power under 246A and enact GST. I have already exercised the powers under 246 and enacted the SEZ Act. Now, what is the effect of that? It attains the status of law. So, once it attains the status of law, you have, can you again trace back to 246A or 246 to find out which is a superior legislation? Is it the law made under 246A or is it a law made under 246? See, they are only defining the power of the legislature and say that notwithstanding anything contained 246 and 254, the anything with respect to GST, union and state would make the law. Do they say that GST law will be more powerful or more superior than the law which is made under 246? It is not so. They are only restricting the powers so that there is no overlapping. If they don't say this, then you will have parallel laws made under by exercising powers under 246 on the same subject. So therefore, should you look at it in that manner, is another thing which, that is my perception. It attains the status of law. Once you make a law, SEZ Act is also a law, then GST law is also a law. SEZ Act says it overrides all other laws. You take IBC also. In fact, it also came almost at the same time when GST law came. I think IBC is little older than GST law. IBC also overrides GST law. Okay, so when it comes to recovery of government dues, the state does not get priority as they got in the earlier laws. The crown debt would assume importance in the old law, but in IBC they get their dues much later, so they are not on par with their status in the old law. So does it mean that GST Act being a superior law will override the IBC law? I don't think you can construe that way. The effect of exercising the power under the Article 246A or 246 is it attains the status of law. Once it attains the status of law, you have to give effect to the law. That is, so when you read it in that manner, then SEZ Act would override the GST Act. IBC law will override the GST Act. Then the Information Technology Act 2000 will override the GST Act. That is how I would look at it. This is my view for the time being. And thank you for a beautiful question. Who has asked this, Arjun?
Sir, I have added, sir. Since there was this was my own query, which I want to.
Oh, your query. That is why it is loaded like a bullet. Anyway, it is a good question you asked. So you also want to trouble us with questions?
No, sir. Just to have a clarification, okay. To have a clarity in the understanding, sir. Sir, there are questions regarding the intelligible differentia and arbitrariness. Manish is going to cover in the second part. So can we postpone such queries to next part of the
Yes,
session, sir? So by this we have
we'll have it later.
addressed.
Yes,
Yes, sir. So
yes,
now
yes.
by now we have addressed all the queries for the first part. So we can break up for a break and we can resume by 11:55 for the second part of the session. Session, sir.
Arjun, can we recollect at 11:50 because there are a
Okay,
lot of many
11:55,
aspects
sir.
that needs to be
Yeah.
covered in
Okay.
here.
11:50. Okay. Yeah. Then we can resume by 11:50.
Okay, sure.
Okay, sir. Thank you.
Thank you.
Hello, Arjun.
Yeah.
I think we can resume now, right?
Yeah.
Okay. Okay, so our next discussion is on something on the 101st Constitutional Amendment Act. Apart from the ones that we have already discussed, there are certain other provisions of the act that also require some discussion. So if you see, Section 19 is in bit contentious for the recent 1 or 2 years. So Section 19 says that notwithstanding anything contained in this act, any provision of any law relating to tax on goods or services or both in force in any state immediately before the commencement of this act, which is inconsistent with the provision of the Constitution as amended by this act, shall continue to be in force until amended or repealed by the competent legislature. This section was notified on 16 September 2016. So its expiry was actually up until 15 September 2016. So a possible dispute that has been arising in the context of Section 19 is that whether from the after the expiry of Section 19, whether the state cannot legislate, whether the states have lost the legislative competence altogether to frame any law with respect to the Sale of Goods Act, or it should be read as a transitional clause within this one expiry period, within the expiry period of this 1 year, if the state legislature have properly enacted the saving provisions for the earlier Sales Tax Act, it should suffice. It should be able to save the recovery of those earlier tax periods tax demands. So in Sheen Golden case, the Honorable Kerala High Court has a decision to argue upon the status of Section 19. The moot question was whether Section 19 is a saving clause or a transitional clause. So if it was a saving clause, then the power to impose tax or to save taxes from the earlier demands, earlier periods would have been lost by the sales states after 15 September 2017. So, in order to save the provisions and in order to achieve harmony in the legislative competence, the High Court of Kerala read this provision as a transitional clause, which with the meaning that if during this period of 1 year, if the state legislate a proper provisions to provide for the recovery of earlier tax periods demands, it would be suffice the purpose. And therefore, since the states have enacted Section 174(2) in their respective State Goods and Services Tax Act, they are well within their power to recover the tax demands from earlier periods. Now, there is a pertinent question. Although the dispute is still there and this decision is before the Honorable Supreme Court, there's a pending dispute, there's a relevant dispute as to whether this provision is a saving clause or a transitional clause. If the argument of the High Court in Sheen Golden case that it is a transitional clause is accepted, then whether if this for the academic discussion, if it to be read that had the state enacted the power to levy sales tax within that 1 year time period, would it have been continued to be the sale of the taxable event would have been continued even after the GST. So what I'm saying is that on the similar lines that the state have saved their power to recover tax, could have they implemented another sales tax act? Now, if this sales tax, since this sales tax act was framed within this 1 year time period, it would have an overarching effect on the GST provision. So, therefore, on this ground, it appears the Sheen Golden judgment might be something with a flaw in there. So therefore, this dispute is a very tentative, contentious dispute, and we shall see how the Honorable Supreme Court deals with this Section 19. Section 18 of the Constitutional Amendment Act provides for the compensation of state for the loss of revenue by the central government, and therefore they have enacted even compensation cess for this very purpose. Now, the question or the observation in this regard is that enactment of Section 18 itself is an indicator of the abrogation of states' power to tax on sale of goods. Because if this Section 18, if the states would have otherwise been empowered to levy tax on their sales, then why would have there been any provision for compensation to them? So this is an indicator of abrogation of state's power to levy tax, or for that matter, overarching effect of Article 246 on the provisions of Article 246. This fact was also noticed in the case of Reliance Industries case also. Then a pertinent question is, since the territory of Union Territory of Ladakh, which is formed with the after the enactment of J&K Reorganization Act, whether the UT of Ladakh can claim compensation for loss of revenue on implementation of GST, which it was earlier supposed to get. Because keep in mind, the state for the purpose of this chapter only includes UT with the legislative assembly. Since the UT of Ladakh does not have a legislative assembly, it does not fall within the purview of state, and therefore it is not it may not be covered within the within section 18 for them to be given the compensation. The difference between a compensation to a state and a union territory is that while the union territory with legislature uh, have the power to collect taxes and the center has to devolve taxes on them, the taxes pertaining to union territory are given in the form of grant. So can the union territory of Ladakh could come to the central government and say that earlier it was getting a compensation for the loss of their revenue, and now the if and now central could decide, or they could give the grant to union territory only as per their violation, and if they do not decide to give any compensation, would it be valid? So there is a pertinent dispute in this regard. Of course, if the center decides to do away with giving the compensation, there might not be any dispute regarding this. In Article 286, there have been amendment as to, first of all, clause 3 of Article 286, which restricted the state's power to impose goods tax on the goods of special importance, which was steel and iron and similar product. That power, that restriction has been done away with, and there no longer remains a restriction on the state's power to tax on the goods of special importance. There is another, of course, we have discussed this dispute regarding the electricity, as to whether this electricity is bound by Article 286 or not. So we'll leave that because we have already discussed it. In other cases, Article 366(12)(a) has been enacted, which defines goods and services tax means. It means any tax on supply of goods or services or both. Now, a contention could be that if it says both, and on the other hand, the services says that it includes anything other than goods. So, if we were to say that if services were to include anything other than goods, then why there was a need to define both? Probably it gives an indication that services does mean everything other than goods, but it does not expand the universe to include other aspects that are not covered as either goods or services, which obviously there is an example of immovable property. So we could say that immovable property is still out of the purview of services. Then obviously we had some small discussion on the continuation of Article 366(29)(a), its conflict with Schedule 2 of the CGST Act. In fact, Rajya Sabha committee had suggested for the deletion of this article. However, for some reason or the other, this article continued. Probably the arguments regarding this could be that the retention of these entries is relevant for the petroleum products only, and therefore this Article 366(29)(a) would not apply in particular clause B of this Article 29A would not apply to goods other than petroleum goods, and they would be covered by Schedule 2. Another argument could be that this Article 366(29) is 29A is repealed by implication. So implication is that although it's not specifically repealed by the Constitutional Amendment Act, however, given the scenario, the situation we are in, it could be the case that the court might declare that it has been repealed by implication, by the not by the expressive words, but the interpretation flowing from the various provisions of the act and constitution. Another argument could be, as I was referring earlier, that while 366(29)(a) only vivisects or creates a component of sale from the transaction of works contract, on the other hand, the other hand, Schedule 2 itself deems the contract as a supplier services. So there could be the argument that these two are not in conflict, at least to the extent of clause B, and they could read it down, or they could modify the interpretation of these articles so as to save them from uh, uh, being repealed, or repealed by implication, or otherwise in conflict with Schedule 2. And obviously, we have an entry 5F, which is in direct conflict with Article 366 29D, 29AD, which speaks about transfer of right to use. The answer might not, I'm not be able to present a precise answer for this, but because we have seen that this only argument to say that this might not be conflicting is by saying that this article has been repealed by implication. Uh, 279A, which has been enacted by in fact, this should be 279A. It speaks about the formation of a constitutional body by the name of GST Council. Now, there is a conflict between the council recommendation vis-a-vis the preliminary delegated legislation also, because if you see the provisions, the principles for making a principle for determining the interstate supplies is being rested with the GST Council, and only if their recommendations of council are there, only on those basis the principle of determining interstate supply could be provided in the law. While if you see the section 12, 14 and 13 of IGST Act, which delegates the power to decide place of supply in certain cases to the parliament without the recommendation of the GST Council, they could be in conflict with the Article 279A, because it is only with the power of GST Council that a place of supply could be determined. Then obviously we have referred to the Reliance. We have observed Reliance Industries case, wherein the court had observed that state's power under 246A is subject to 279A. But that means is that state cannot come out plainly and legislate a tax on supply of goods or services tax based on its own volition. It has to get the recommendation of the GST Council. To what extent this is a good interpretation, we have to obviously see. Um, there is another article 279.11 which speaks about formulation of mechanism by the GST Council for the interstate dispute between Government of India and states. But we have already have Article 131 of the Constitution, which gives original jurisdiction to the Supreme Court to decide disputes between the interstate disputes between the Government of India and the states. But still, this is since till a mechanism is established under 279A, it could be said that Article 131 is still available to the states to bring this dispute before the Supreme Court with the state or with the other states or the central government. Naveen sir, if you have anything on these aspects.
Yes, Manish. If you look at section 19 of the 101st Constitutional Amendment, which Manish was referring, the basic issue which has cropped up is whether the department could issue a show cause notice to recover taxes under the past regime by exercising the powers under section 174 of the CGST Act, which is a repeal and saving clause, which appears to be in conflict with section 19 of the Constitutional Amendment Act. We all know Constitution is superior, therefore Constitution overrides the provisions of CGST Act. That is the basic argument which was advanced. The point here is section 19 prescribes a sunset clause. It is like prescribing expiry date for medicine. After the expiry date or sunset clause, there is no power to exercise jurisdiction to demand tax. And therefore, whatever had to happen, the department should have taken steps prior to 15th September 2017 is the basic argument which is advanced. In fact, we also saw a recent judgment of the court. Some in some state they attempted to increase the time limits under the old law. Manish, is it Kerala or which state is that? They
It's
and
in
the
the
court
Kerala,
said,
sir. Kerala, yeah.
yeah,
In Kerala, in fact, they
as-
had increased the limitation, and in fact, the Kerala High Court, in the case of AA Baiju, had held this power to be ultra
yes,
virus of the constitution.
correct.
And in
So
Madras, oh sorry, in the state of Maharashtra and Goa, they have similarly introduced some kind of provisions.
I think after this COVID situation, you may find some judgments there also. So, can you
Right.
exercise powers under the repeal law was the question. When the law itself is not there, where is the question of extending the time limits under the particular law? That was the issue which came up for consideration. As far as the conflict between Section 19 of Constitutional Amendment Act and Section 174 of CGST Act, the Kerala High Court in Sheen Golden Jewels case has not accepted that argument. In fact, they said that 246A itself saves the power. That is what they said in Sheen Golden matter. Even the Karnataka High Court has not accepted that argument. They have rejected the writ petition. I am sure the matters, this issue has cropped up across the country, and ultimately it is for Supreme Court to decide the issue. So wherever it is possible, this argument is being raised. Although many of the assessees may not be willing to knock the doors of the High Court at this stage, but this argument has been raised in many matters. And if you look at the other aspect, Section 18 only says that the Parliament by law on the recommendation of GST Council provide for compensation to the state. They say that give compensation to the state, have a law for that. Can you read it as an authorization to impose a levy or a tax in the nature of compensation cess? That was the issue which was considered in that Mohit Minerals case. And I'm sure this aspect needs to be further argued. Maybe in some other future matter, this issue will again come up. Then coming to the issue relating to uh, the definition of service, which Manish touched upon. The definition of service in the constitution is also very wide. Service means anything other than goods. You will have a similar definition adopted in the GST Act also. There also they would say anything other than goods, money and securities, and this is how they have adopted the same thing. Now the question is whether it encompasses immovable property transactions, and that is where we may have to refer to the definitions of immovable property in the General Clause Act or Transfer of Property Law or Indian Registration Act. Immovable property is a very widely used, widely expounded principle in the context of other laws, general laws, although it is new for GST law. So therefore, immovable property in General Clause Act includes land, it includes the interest in land, it also covers the benefits arising out of land. Fishing rights are treated as part of immovable property. And one more thing which was pointed out was this mineral rights. When I give mineral rights, whether that right is in the nature of a profite pondere, it's a Latin maxim. So whether you can say it is a benefit arising out of land, and therefore it is the GST cannot be imposed on it. The reason why these issues are cropping up is stamp duty is not subsumed in GST law, and therefore can service be defined to encompass even immovable property transactions. So, for example, this renting of immovable property is an issue which is pending before Supreme Court under service tax law. Is it a service in the first place is the question pending. Similarly, joint development rights, is it subjected to tax? Is it subjected to GST? Can it be subjected to GST is a question which would crop up. Then coming to 279A, I was pointing out in the beginning that GST Council has become more powerful than the Parliament and states when it comes to legislating on GST. Does it affect basic structure? That issue is still open. Then, as far as the point relating to recommendation of the council regarding establishing a mechanism uh, for deciding disputes between the union and the state, I think that mechanism is already in place in the form of the GST tribunal, where they say that whenever there is a conflict as regards place of supply, where one of the issues is place of supply, whether it is X state or Y state, then the issue will be decided by the national bench of the tribunal. It will not be decided by the zonal benches of the tribunal. It is another matter that the uh, the tribunal has not been constituted because they are facing a legal issue. The Madras High Court had quashed the provisions relating to tribunal on the ground that it is imbalanced. All the three members come from the executive, two are from the one is from the IRS, another person is from the state officer, then one more person, even the legal judicial member is from IFS or ILS, Indian Legal Service. So that was challenged and relying on R. Gandhi's case, the Madras High Court has said that you cannot have such a constitution. They have not taken any steps even in the recent budget. That is going to pose difficulty because some of the uh, orders of the appellate authority, first appellate authority, have been passed and you have no forum to go. You have to go and land up in the High Court by filing a writ petition. Maybe they should think of some independent tribunal like what you have for this Kaveri dispute. You have this Kaveri tribunal. Like that, they should have thought of something for resolving the dispute between states. I see a lot of issues which would come where the states would try to demand their share of tax, saying that the taxable event occurs in their state. So we have to see how the government is going to resolve this controversy regarding constitution of tribunal. Over to Manish.
Yeah, thank you, sir. So I'll quickly come to CIS, the topic. CIS, as we already discussed, is a tax and is generally used when the levy is for some special administrative purpose. It is not forms part of the consolidated fund, but it is credited to a special fund, and the funds are to be utilized only for that purpose. So if we see that there is a compensation cess, it is only available for distribution to the compensation for the loss of revenue to the state. So the Kerala flood cess is there. It is only for the Kerala flood that has been encountered in Kerala and to recompense that expenses that Kerala government had to undertake. Now, there is a pertinent dispute in Article 270, which says that tax is levied and distributed between union and the states. Now, this Article 270 do not appear to provide a levy of a cess. So, if Article 270 does not provide for a levy of cess, then there is no other specific power under the constitution to provide for the levy of cess. In Mohit Minerals case, the Supreme Court has traced this power to levy cess under Article 270. But however, if we see that Article 270 literally, if the words levied and collected are referred as disjunctively, the expression levied and collected does not appear to be empower making laws for the levy and collection, but it only indicates the extent of tax, cess, and surcharge that are covered. That means it only speaks about the distribution of the taxes, cesses between the union and state. It does not empower ipso facto a levy of a cess. Then the question, the observation in Mohit Minerals was whether the constitution, it says when constitution provision empowers the parliament to provide for compensation to the state for loss of revenue by law, the expression law used therein is of wide importance. So when we, as Naveen sir was saying that section 18 was referring to law for compensation, was it wide include to provide for a imposition of a tax? It doesn't appear to be, because the expression provide for appears to be only for how this compensation would be determined, rather than imposition of a cess ipso facto. So this observation of Mohit Minerals also appears to be debatable. Then another observation was the power to make law thus is not a general power. It relates to a journal entry. So in this observation, what the court said, then we have the power to levy cess is also traceable to Article 246A. Now, if that is the case, is if the power to levy cess is traced to Article 46A, then the uh, whole idea behind imposing a GST would be rendered meaningless, because it would empower the states to come across the uniformity and levy cess as per their own volition. So these pointers in Mohit Mindra's case are somewhat debatable. So yeah, so this was regarding cess. So Naveen sir, if you could permit me, I'll just quickly wound up the rest of the session because of the paucity of time, and then probably we could have some discussion.
Yes, sir.
Yeah.
Sure, sure.
So I'll quickly come. Sure. Thank you, sir. So I'll quickly come to Article 14. Article 14 is basically one of the chapter part 3 of the Constitution, which starts from Article 12 to Article 32. So there is a Article 13 says the state shall not make any law which takes away or abridges the rights conferred by this part. Article 14, 19, and 21 are popularly known as Golden Triangle of the Indian Constitution. The Golden Triangle provides full protection to individuals from any encroachment upon their rights. Article 14 is a very important article. It says the state shall not deny to any person equality before the law or the equal protection of the law. So there are two limbs in this article. One is equality and the other is equal protection. Equality on one hand is a negative concept, that is it should be read negatively. That is, there should be no law that should be able to discriminate between people. While on the other hand, equal protection of law is a positive concept. It says that every person would have equal protection of the law. Now, the basic test behind Article 14 is a twin test. It is we could refer to the judgment in state of West Bengal versus Anwar Ali, wherein the High Court, wherein the Supreme Court said that reasonable classification. It imbibes on the idea of creating an intelligible differentia. Am I audible? Hello? Am I audible? Arjun?
Manish, we lost you for a couple of minutes. You start with Article 14.
Okay. Yes, sir. So basically, the Article 14 is a two limbs are there in Article 14. One is the equality, and the other is equal protection of law. Equality is a negative concept. That means it says the state should not discriminate between people. And the other, equal protection, is a positive concept which says that there should be equal protection of law for every person. The Article 14 basically resides on the classification doctrine as was originally propounded by the USA courts. It imbibes on the idea that classification by legislature is permitted, because if the classification is not permitted, then unequal will also be treated as equal, which is not the case, which does not suffice the case of equality. So it's subscribed to the classification doctrine, and the twin tests are laid down in the state of West Bengal versus Anwar Ali Sarkar. It's a landmark judgment, and subsequent followed in other cases also. So I'll read paraphrase. In order to pass the test of permissible classification, two conditions must be satisfied. It says that classification is permitted, but that classification must satisfy these two following tests: that the classification must be founded on an intelligible differentia, which distinguish those that are grouped together for others left out of the group. And the differentia must have a rational relation to the object sought to be achieved by the act. So it says that you can classify between people, but that classification should be on some objective, some intelligent objection. You can differentiate between the people of a male and a female. You can differentiate people of a richer class and poor class. So it has a reasonable differential, but at the same time you cannot differentiate between the two persons falling within the same class. uh, Second, the classification should have should have a reasonable object, should have reasonable nexus to the object achieved by the sought to be achieved by the act. So if you say the object of income tax is to impose tax, then the differential that you are creating by creating income tax slabs, it should have reasonable object with the collection of income tax. You have a purpose to collect income tax on the basis of administration convenience, that you will collect higher taxes from the higher class, richer class, and you will leave it to the small poor people to, because they are not anyway in so much contributing, would be required to be contribute towards the consolidated funds of India and towards the greater cost. So therefore, there is a differential between the richer class and a poor class is also has an object with what was supposed to be achieved by the income tax. In Maneka Gandhi, it was another argument. It was also held by the Supreme Court that Article 14 strikes at the arbitrariness in state action and ensure fairness and equality of treatment. The principle of reasonableness, which legally and philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence. So, in Maneka Gandhi, another principle of Article 14 was discussed, that it seeks to strike at the arbitrariness of the action. The arbitrariness means that you create a class-wise legislation, a classification which is arbitrary. So it says the classification should not be arbitrary, but it should be based on some intelligent quotient, or it should be some when you're classifying, it should have some reasonable basis for classification. And of course, this Article 14, as has been held by the courts, is applicable to the tax laws also with no exceptions. But there is a wide latitude given to the legislature when it comes to the taxation statutes, as has been held by many times in by the higher courts. Uh, with that in mind, a probable question could be whether the Rule 36(4) of the CGST rules, which do not distinguish between the bona fide service recipients, supply recipients, and other recipients, could it be said that it does not create a differential and it imposes to create unequal as equal? So, because Article 14 seeks to strike down at the creation of equality between equals and inequality between the unequals. So therefore, when Rule 36 do not create a distinction between unequal and treats all of them as equal, could it be liable to fall wise of the Article 14 of the Constitution? We may have to see. Similarly, in one Gujarat High Court case, RSPL Limited versus Union of India, the Gujarat High Court had held that Section 145 of the CGST Act, which only prescribed for inputs goods transitional credit, was valid. Was valid, and there was a reasonable distinction between inputs and capital goods, and therefore capital goods transition credit was not being allowed. So probably this decision is also open to accessible to challenge again before the Supreme Court, because the distinction between the differential between capital goods and input goods is not perceivable by a normal man, and both appears to be good. So distinction between these is also susceptible to challenge of Article 14. We have a concept of manifest arbitrariness. Probably we could leave it to the another session that we will have in the next week, wherein later broad details of this concept would be discussed. Because of the paucity of the time, I'll leave it up for today. Then we have another article, Article 19, which is a freedom kind of fundamental rights. It says you have freedom to speech, you have freedom to move, you have freedom to multitude of the things. subclause G of clause 6 says that all citizens shall have the right to practice any profession or to carry any occupation, trade, or business. So there is a vehement argument that any restrictions that causes the free 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 will of a person to practice any profession, it would be it would be unconstitutional for the state to impose these kind of restriction under Article 19(1)(g). So, of course, although there is a restriction, but of course, reasonable restrictions could be imposed on this right. Reasonable restrictions is a trust point. It should not be person specific. It should be in the interest of a general public. Taxation statutes is per se not, I mean, levy of a tax is per se not a restriction to freedom. And of course, the excessiveness of tax is also not by itself is not violative of Article 19(1)(g). Now we have seen cases in the context of Senvet credit, wherein Rule 8(3)(a) of erstwhile central excise rules was prohibiting utilization of Senvat credit if the manufacturer is not able to deposit the tax, is not able to deposit the excise duty within the 30 days of due date. So in those cases, Gujarat High Court and after that multiple other High Court held that denial of credit. In fact, it said if the Senvet credit facility is withdrawn, ability of manufacturer to continue business under adverse financial climate would further diminish his possibility to continue business. So in these grounds, the courts have held that denial of a Senvet credit in an unequal way, in a affront to your practice to profession, is also false vice of the Article 19(1)(g). So we could have a similar proposition when it comes to Rule 86 of the CGST rules, which empowers the commissioner or any other authority to block ITC of any CGST based on the criteria given therein. So it appears that those blocking of Senvat credit or I would say input tax credit based on the illusory power of the commissioner or any other authority may fall vice of the Article 19(1)(g). Then we have some other article constitutional provisions. I will quickly sum up in this regards. Article 21 and 22 protects the personal liberty of a person. So it basically the reason of courts holding down that illegal arrest and arrest without proper care are basically null and void. So the basic premise of these of illegal arrest being not constitutional is Article 21 and 22. DK Basu is a very landmark judgment which may be referred to explore the contours of these articles. Then we have Article 286. Now, Article 286, under Article 286, states are not empowered to impose tax on interstate supplies of goods or services. Now, we have a very pertinent question as to the taxability of intermediary services. We leave that for a moment that intermediary services, you have to pay IGST. Suppose you have, since we take a situation that since the place of supply of the intermediary services is the location of service supplier, so in that case, the correct taxes appears to be CGST and SGST. However, by virtue of this, now my basic premise was that a person sitting in Karnataka was providing intermediary services to a foreign service recipient, say located in USA. Now these services were actually appeared to be services in the course of interstate trade or commerce. However, by virtue of your fixing place of supply, these taxes become CGST and SGST. Now, the question could be whether the SGST, that is, if levied by state, would be susceptible to challenge under Article 286 or not. Article 300A is provides for the protection of the personal property. It says a personal property of a person will not be deprived unless provided by the law enforced. So Article 300A was earlier part of the fundamental rights, but it was later on moved on to Article 300A for the purpose of for enabling the legislatures to subscribe to the land owned by private party. It had some background to it, but I'm not going to it right now. The question is in the context of ITC, which was in the case of brand equity by Delhi High Court and Siddharth Enterprise, the Gujarat High Court had held that ITC is a personal property and it cannot be deprived. So, by this recent amendment in section 143 or 140 of the CGST Act, the statute has limited, in fact, provided the time for the fixation of carrying forward a transitional credit. However, it does not appear to be uh, validating the argument of these courts that this is a personal property which cannot be taken away without a law. So the question is, by virtue of section 140, can the government take away my property without being provided by law? And now the question, and now a fundamental part about Article 300A is that if you deprive any person of his property, it should be just, reasonable, and fair. With just, reasonable, and fair, it means that there should be compensation. There should be, cannot be a case of no compensation. Although nil compensation is suffice. Probably to details, for further details in this regard, a judgment in the case of KT Plantation may be referred into, which is a landmark judgment. And the basis, on that basis, a argument could be formulated that since IT is a private, is a property of a person, taking away in the garb of section 140 of the CGST Act is not is taking away my vested property without providing me a compensation, which is invalid under Article 300A. Then, as earlier Naveen sir was talking about policy directives. These policy directives, although are not mandatory, but over the years the court have exacerbated the status of these policy directives and to an extent bridge the gaps between policy directives and fundamental rights. So Olga Telly's judgment was a very good judgment if anybody wishes to read further on these policy directives. I'm not able to go further into this because of paucity of time, but say in the next session we could have some discussion with one of the aspects, which is promissory estoppel. We could discuss, we could bring in a concept of policy directives in this regard. Then there is a possible gap in definitions also, wherein this definition of supply has not been provided. Now there is an argument when we say that supply definition has not been provided, and if you are to provide supply through CGST Act, so can how would a person say that the supply that is being provided under CGST Act is not overarching with above the constitutional provisions? So probably we have to, because this is a larger discussion, I leave it for the time being, and I'll also leave Article 367 for the time being. I'll briefly discuss what a judicial review is all about. Judicial review is nothing but a power of a higher court to strike upon those provisions which are contrary to the constitutional provisions. So the law in this regard was developed by a very famous case in Marbury versus Madison by the US Supreme Court, when it says that where a provision which appears to be contrary to the constitutional provision itself, then it is liable to be struck down, even if the same is laid down before the legislature. In India, the Supreme Court Advocates on Record Association versus Union of India is a landmark judgment in this context, which may be referred into. Uh, the scope of judicial review is basically on constitutional amendment to the extent of non-abrogation of basic structure. Now, basic structure is again is a preservation of the basic principle of the constitution. That is, although a legislature can amend the constitution, but it cannot affect the basic structure. So, a judicial review on with respect to constitutional amendment is only to the extent it does not abrogate to the basic structure. Otherwise, the judicial review is not permitted. Then obviously judicial review with respect to legislative act is subject to the twin test of legislative competence, whether the state has the legislative competence to enact tax and the compliance to the fundamental rights and other constitutional provisions. With respect to administrative actions, the power of judicial review is very wide, in as much as illegality, which is error on law, jurisdiction, violation of principles of natural justice, perversity, then irrationality, reasonableness, procedural impropriety, proportionality, legislative expectation. All of these kind of action of a administrator or an executive are susceptible to the judicial review by the higher court and Supreme Court. Now, if we could see some of the provision like Napa Authority 1 Section 70, 177, 171 is challengeable both on the Legislative Act in as much as it violates it to an extent violates Article 19(1)(g) of the Constitution, and also as an its administrative rulings of National Anti-Profiteering Authority are also susceptible to judicial review as an administrative actions, and the extent of or the threshold of judicial review with respect to administrative action, that is the orders of Anti-Profiteering Authority, are wider. Similarly, the GST Council actions, which is a constitutional body, is also subject to judicial review without any interference from the government. Judicial review remedies are available under Article 32 before the Honorable Supreme Court, wherein a writ could be, where an application could be directly filed before the Supreme Court for enforcement of the fundamental rights. Similarly, an application before the High Court of the state can also be filed for enforcement of fundamental rights or for enforcing any other action. So the scope of High Court is higher than the scope of Supreme Court in terms of passing of the order. High Court enjoys larger latitude in terms of their power. Of course, there are principles of dismissal of SLP in limine at the threshold does not mean raising of the judgment of High Court or Supreme Court. It is only a threshold dismissal which does not form part of the law. Otherwise, all law that are passed by the orders that are passed by Supreme Court are law of the land, and is binding on all courts and authorities within the territory of India. Then Supreme Court obviously exercise some judicial restraint in as much it does not entertain cases on merits. It also delegates matter wherein alternative remedy is available. Similarly, there are policy decisions which cannot be susceptible to judicial review unless they infringe constitutional provision. So as we were earlier referring to policy directives that are contained in part 4 of the Constitution, over the years, although they have the courts have bridged the gap between policy directives and fundamental rights, but as is on a ipso facto basis, policy directives are not as is challengeable before the courts in terms of their judicial review power. Further, the writ can be filed in case of substantial injustice and not mere technical infraction of law. Over the years, the jurisdiction by the court is usually exercised by the courts, ignoring the alternative remedy, wherein following 5-6 cases are illustrative examples are there. So in these cases, the courts would ignore the argument of the state that although alternative remedy is available, when these situations happens, the court can exercise their jurisdiction in original form. So with that, we could conclude the session for today, and I would request Naveen sir to provide his valuable comments on the later discussion, and then probably we could have some questions. Thank you so much.
Thank you, Manish, for taking us through various provisions. Arjun, what time we are supposed to end the session? Arjun?
Arjun?
Yes, sir. Yeah. With this,
What time we are supposed to end the session? It goes on till what time?
1:30, sir.
Okay, fine.
Okay, we have this time. I didn't
Actually,
know about that.
The deliberation would end on by 1, sir, and 1 to 1:30 we will allocate for Q&A.
Would you like to, Manish, would you like to go to that slide relating to, you had said that you had reserved it for some other day. I think we can finish that.
Okay,
Article
I think, sir,
21.
it was,
Yeah.
yeah, yeah, yeah. So, two, three things are in fact are there, sir. Manifest arbitrariness, because we are covering legal maxims in the next week. We'll be able to cover up in that session itself.
Okay.
So,
Probably I can,
sir,
we can speak about, yeah. Yes, Arjun.
it's not an issue, sir. If you want to close it early, we can move on to Q&A and we can close early today. There is no such
No, no, actually we
restrict
have
to time limit.
more to discuss. That is why we
Yes,
are
sir.
just looking at it. Manish, you want
Okay.
to add few more
Yeah.
points, then I'll take over.
Yes, sir. Sure. So Article 21 basically protects the personal liberty of a person. We have seen that GST officer are exercising arrest these days, and these arrests are basically on the mere suspicion that the person might be a might abandon, and he would just uh, leave the country or leave the premises, and he might not be traceable. And in that gap they are avoiding the natural principles, that the principles of natural justice and other principles that are provided in the Indian Penal Code. So Article 21 could be brought into in these cases where the persons could contend that arrest is supposed to made within the guidelines formulated by the Supreme Court, and it's also the guidelines that have been provided under the Indian Penal Code. So, or I would say the Code of Criminal Procedures. So, in these cases, a person should not be arrested after the sunset hours. A person who is arrested, he should be brought within the judicial magistrate within 24 hours of him being arrested. Then he should be given the option to bail, provided the offense is bailable. And obviously, we have a pertinent dispute with respect to GST matters, wherein the question is whether an arrest can be made by the GST officer without first assessing the tax payable by him. So in PV Ramana Reddy case, the Telangana High Court has held otherwise. It has held that the arrest provisions could be invoked by the GST officer without resorting to assessment first. However, the case in the facts in the PV Ramana Reddy case was a indicative of fraud by the person present. He was not able to vindicate his bona fide, and therefore it appeared that the High Court went in large and held that arrest could be made without resorting to the assessment provision. However, in later cases, like one held in Punjab and Haryana High Court and the in the Madras High Court also, these courts have held that before resorting to arrest provision, there should be a determination of taxes. Now, in combination, all these cases are uh, laying down different rules and criterion, and the matter is pending before Supreme Court whether a tax needs to determined before an officer could issue the order for arrest. So probably in this case, Article 21, because it secures the personal liberty of a person, even that arrest, if satisfied by the provision of arrest is satisfied by the GST officer, then also he must be following the provisions of Article 21 of the Constitution. In fact, in one recent cases, one GST officer resided at the house of payable person for 7 or 10 days, and the High Court, Gujarat High Court, reprimanded the actions of his and directed the state to take strong actions against him. So these are the cases where Article 21 is put into argument by the SSEs, and most of the times the High Courts and Supreme Court usually entertains where a personal liability of a person is infringed. In fact, we have seen cases in Information Technology Act also, wherein the Privacy Act was in dispute. Then there was a dispute regarding the Section 377 of the Indian Penal Code. This article of 21 is relevant where a person feels abrogated of his physical health and mental health. So I would refer Naveen sir to add if I have missed anything on Article 21 and 22, and probably on Article 367, which provides for the interpretation. It says that provisions of the General Clauses Act 1897 would be relevant for interpreting the provisions of the Constitutional. But assuming that the General Clauses Act has, or I would say Article 367 has has borrowed the provisions of General Clauses Act, it does not ipso facto means that all provisions of General Causes Act would be applicable with respect to Constitution. So if I say, let's say Section 6, 7, and 8, which speaks about savings and repeals clauses in the General Clauses Act, it does not ipso facto become applicable in the garb of interpretation of Constitution, because these sections do not interpret the law. These are basically generic provisions, and Constitution does not borrow generic provision of the General Clauses Act. It only brings interpretation provisions, which is the definition clause in Section 3 and other clauses like interpretation of the previous presidential value and all those. So it could be, in fact, in Reliance Industries case, the Gujarat High Court had commented on this aspect also, because it has a repercussion. If you are to see that entry 54 that we are talking about is abrogated by Section 19, the argument of the states could be that entry 54, although not saved by Section 19, but it could be saved by Section 6 of the General Clauses Act. Now, if it General Clause Section 6 of General Clauses Act is not at all applicable to the Constitution, the states are again left empty-handed, and again entry 54 in its pre-amended form could not bring into question as to saving of the Section 174 with respect to previous sales tax demands. Uh, I think I have concluded, sir. I would request you to
Okay,
add on the pointers.
okay. Thank you. Uh, Coming to Article 14, which talks about right to equality, the courts have consistently held that equal should be treated equally and unequal should not be treated equally. That is why you will, in the matter of exemption, you will find that there is some discrimination. In fact, discrimination is permitted provided it satisfies the test of intelligible differentia and reasonable classification. Uh, then I'll give few examples how Article 14 may be pressed into service in GST law. Take advance ruling. You are finding so many advance ruling. Of course, most of them are favoring the revenue, but there are some advance rulings in some states which are also favorable to the assessee. There may be cases where a person goes to the advance ruling authority, he he gets a favorable ruling from the authority. Another person goes after 2 months, the authority takes a different view. That is a case of a case involving discrimination, which will not even pass the test of intelligible differentia. Facts are same, circumstances are same, but decision is different. Similarly, different states, different advanced ruling authorities taking different views, that can also be challenged before the court. Now, there are some advanced rulings which are favorable. Now, tomorrow, if the department commences proceedings against someone who has not gone to the advanced ruling authority, but he has followed the ruling in some other case which is favorable to taxpayers. Suppose the department starts adjudication proceedings, can it be challenged as discriminative? In fact, if you look at I remember reading some judgments in sales tax and VAT context where the courts have said that you cannot the advance ruling is binding on that particular taxpayer who went before the authority. But as far as the department is concerned, they have to be consistent. They cannot be inconsistent. In one matter, they take one view, another matter, some other view. That actually amounts to discrimination. So they should be consistent even in adjudicating matters, and particularly when it comes to rulings which are favorable to the assessees. Then one more thing which comes to my mind is that recent Sabka Vishwas scheme which we had in the context of old indirect tax regime, whether that is hit by discrimination, because you would clearly define that only these type of persons can go and get the benefit under the scheme. You can read the judgment of the Supreme Court in R.K. Garg's case, which is which was rendered in the context of income tax. There, they have laid down principles as to how you pass the test of this intelligible differentia and reasonable classification. So the Sabka Vishwas scheme does not apply to all. There are restrictions, but you can always defend it on the ground that it satisfies Article 14 of the Constitution. Then one more thing about this Article 19, which he was referring to, whether it affects your right to carry on your business. That was one of the issues which cropped up in some of the judgments, whether imposition of sales tax or income tax affects your right to carrying on business or profession. In Express Hotels case, the Supreme Court said mere excessiveness of the tax or the fact that it affects the earnings of a person is not sufficient to hold that it violates Article 19 of the Constitution. So it is not as though you can challenge every tax on the ground that it affects your business, therefore Article 19 is affected. You cannot take that ground. As far as blocking of credit is concerned, according to me, it is certainly without the authority of law. One fine day when the person opens his GSTN portal, he gets a notice that your credit is blocked, you cannot use it. In fact, in all these cases, the due process of law has not been followed. The procedure established by law has not been followed at all. And certain taxpayers have gone to the courts. Courts have been consistently holding that you have to follow the due process of law. It also violates Article 20, where the procedure established should be followed. Then coming to this personal liberty under Article 21, power of arrest is conferred in most of the taxing statutes. And there are certain norms, like what Manish was mentioning. Within 24 hours, you produce him before the magistrate, tell him why he is arrested, what is the contravention. That is why they come on Saturday evening when the court is closed. So the courts have gone to the extent of saying that you produce that person before the magistrate in his residence, so that if the courts are closed for public holiday, still the fundamental right under Article 21 could be complied. And Article 21 would also give us the principle that the worst criminal would be entitled to best defense. In Ajmal Kasab's case, although we all knew everything was captured on camera about the terrorist act, but still the courts ensured that adequate legal assistance was given to him and he was brought to justice. Then coming to the issue relating to judicial um, review, The courts have held that judicial review is a part of basic structure of the Constitution. And as I told in the beginning, preamble talks about the basic structure as interpreted by Keshavananda Bharati's case. So whenever there is an interference of judicial review, it can be questioned before the court. Then coming to judicial activism, there are various instances where the court itself suo moto takes cognizance. For example, during this COVID crisis, they realized, the Supreme Court and the High Court, that there may be a lot of limitation which may be expiring during the period under lockdown. So people are not allowed to go out, factories are closed, businesses are closed, there is no proper courier or postal services, everything is crippled. So they took up suo moto and said that the limitation would be kept in abeyance. This is one instance of judicial activism. And there are various types of writs which are possible. In GST also, many matters have already gone to the High Court. When do you go to the court? Directly, without exhausting the alternative remedies which are explained by Manish. Suppose you want to challenge a particular rule, circular, provision as ultra vires the act or unconstitutional, then you have no remedy but to go to the High Court, because statutory creatures cannot decide that. Similarly, when your fundamental rights are affected, then you would challenge it before the court. And there are various types of writs. For example, habeas corpus, which is generally invoked in criminal cases. Habeas corpus means have the body. Person is arrested and you pray for protection of that person before the court. Mandamus is one more type of writ, where mandamus is a direction given by the court. In fact, someone, as a CA, came to me about a couple of days back. We were discussing an income tax matter where the refund is kept pending for 7 or 8 years without any reason. You write reminders, there's no response from the income tax. So I told this is a fit case to go to the High Court to get a direction to consider the refund claim. So, and co-RN to, you question under what authority a person is acting. Jurisdictional issues can be raised. Certiorari, you are challenging the validity of some action. It may be validity of the order or validity of a rule, circular, provision, etc. So various types of writ remedies are available. Sometimes we also ask for a combination of writs. It is not as though that you file one writ petition, you should ask only for one type of remedy. It can be a combination depending on the facts. For example, the department wants to auction the goods which are seized without issuing show cause. I will ask for a writ of prohibition. I will also ask for a writ of mandamus, directing the authority to take up the matter for adjudication. So you have to work out the remedies based on the peculiar facts and circumstances of each case. So these are some of the observations I had. Over to Arjun, if there are questions which we can take up.
Yeah.
We have
Yes,
half an hour for that.
Yes, sir. So now we can move on to query section. So the first query relating to the second part of session, Manish, this is regarding Article 14. So the query is relating to the refund provisions, where Rule 89 restricts the exporter when he is exporting under LUT to avail the refund of capital goods. And further, for inverted duty structure, there is a restriction for claiming refund of input services and capital goods. So under your purview, whether such discrimination of input tax credit for the purpose of refund, is it violating the Article 14, or is it a reasonable classification?
Uh, So the quantum of determining reasonable qualification rests upon the legislature or the executive that has been doing such class legislation. In courts, in various judgment, it has been held that it is not a hard and fast rule that every class that legislation should have some kind of a arithmetic connection with it, that they would have to justify why the capital goods are being excluded from inverted duty structure and the LUT, but it should have some reasonable expectation. So if I could examine or I could think of why the capital goods have been excluded, it might have been the case that capital goods last for a duration of the period. Unlike the inputs that are currently traceable and over 1 year or 2 years, the capital goods that are the ITC on a capital goods is not traceable to any particular tax period. It usually ranges between 5 to 10 years, or in fact higher. So probably they are not able to administratively determine or provide for the refund of capital goods with respect to IDS and LUT refunds. Probably they are trying to create a classification which might be justifiable before a court also, because the court also accept the pleading of the parliament and the state that administrative conveniences also has to be kept in mind before application of Article 14. But at the same time, there is an also question, well, determining the reversal of common ITC with respect to capital goods, they have a provision in the form of Rule 43. So anyway, a person could definitely challenge the exclusion of capital goods from IDS and LUT. However, it needs to be seen, because the way on this is very the threshold of the argument could be very fewer, or the weightage would be very less when it comes to succeeding before the court. Naveen sir, if you want to add anything on this.
Yeah. See, when it comes to interpretation of Section 54(3), in fact, I had the opportunity of examining this issue a couple of days back. We are contemplating a writ petition before the High Court. If you look at 54(3), which relates to inverted duty structure refund, the provision says in very clear terms, the main body of 54(3), it says, subject to the provisions of subsection 10, a registered person may claim refund of any unutilized ITC at the end of any tax period. Now, if you look at the answering the question which Arjun asked, it is not a case of violation of Article 14 or any other fundamental right. It is a classic case of misinterpretation of Section 54(3) itself. When the law uses the expression any unutilized ITC, ITC is defined in a very wide manner. Any credit of input tax, and input tax would include the credit relating to input capital goods or services without any restriction. So when they say that you are entitled to refund of any unutilized ITC, and very clearly said so in the main provision, the proviso, what is the effect of a proviso? A proviso is only an exception to what is said. A proviso cannot be used to eclipse the main provision. A proviso, the proviso, what is the effect of proviso there? They only say that in case of inverted duty structure, if it arises on account of nil rated or fully exempt supplies, then you are not eligible for refund. That is the only restriction. That does not mean that the refund should be allowed only in respect of inputs. That is a clear case of misinterpretation. I am sure this will go to the court, and they will read the law as it stands in the statute book. Proviso has been used to negate the main section itself. That is my personal view on this. Yes, sir.
Thank you, sir.
And in
Moving
fact,
to next.
Arjun, if you
Yeah.
just one comment, Arjun here, and if you see in respect of IDS refund claim, right? So the whole concept gets diluted the moment you exclude input services and capital goods out of the purview of refund. Because if you see, a product is manufactured out of input services, and capital goods. So there is a contribution of inputs, input services, and capital goods. Now, if you remove the whole quantum of input service and capital goods, the product of 100 rupees gets converted into 30 rupees. Now, if you are seeing the inputs, when I'm comparing inputs versus outputs, you are seeing the inputs of entire 80 rupees, but compared to that, you are seeing the inputs of 30 rupees. That creates a dichotomy as to you are not providing a correct formula for the refund under section 54(3). That's it. Yeah.
Okay. Yeah. Moving on to next query. This is relating to Article 19(1)(g), where there is a freedom to practice business and profession. Can you also explain on that reasonable restriction with the Article 19(6) says, however, the government may provide reasonable restrictions for conducting the business. So many of the queries has been raised by the participant whether Rule 36(4), that GST or 2A restriction, is it violating Article 19(1)(g), or that section 16(2)(c), where the supplier has to make payment, whether such kind of conditions are violating Article 19(1)(g). This is the query.
Okay. I'm giving my comments, but I would more specifically require inputs from Naveen sir. So if you say reasonable
Okay.
restriction, in essence, it
Mhm.
seeks to cure that reasonable restriction should be in the public interest. It should be leviable. It should be applicable
Mhm.
for the general public. And if you see
Mhm.
that uh, there is an liquor sale is prohibited or is controlled by the state
Mhm.
government. So
Okay.
state government, in order to regulate the power, so that no so that all of persons with the small capacity do not enter into this business, they impose a very large amount of liquor license fees. So they're trying to regulate this practice of liquor sales. In essence, they are putting a restrictions in the form of liquor license fees, so that the liquor business is controlled. So that could be called as a reasonable restriction, in my view. Then you could have another kind of practice like trading in tobacco, trading in other sinful goods. There also the state could impose some reasonable restrictions, because these are sinful goods. These are not should be available as is the case of other generic goods, because you can impose uh, in fact, you could see the excise duty that is still being levied on the tobacco products. In that case, also there is a very strict guidelines of the authorities. In fact, it is regulated by the superintendent of a central excise commissionerate always sits at the factory gate, so as to foresee the process of removal of the tobacco products. So these are the cases where a reasonable restrictions are justified for the regulation purpose. Of course, if you see Rule 36 for to an extent, it could be to the extent it does not it creates a classification between bona fide persons and non bona fide persons. If that classification is made out by the government, and court happens to read it down to be applicable to only non bona fide purchasers, then probably it could be said that it does not expressively violate Article 19(1)(g). Any other provision that has been quoted by attendees that you want me to comment on?
No, no.
Okay.
Only
So,
36(4).
so Naveen sir, if you could add on this or provide your otherwise comments.
See, the Constitution itself provides for reasonable restriction in respect of all the clauses in Article 19. In law itself, the general principle is no right is absolute. Every right has a duty which is attached to that, and that is also reflected in all these fundamental rights. So restrictions can be placed, have been placed. The only thing is The Supreme Court has consistently held that however stringent the restrictions may be, they must stand the test of reasonability. This is what the courts have said consistently. Now, when it comes to this 36.4, is it that matching related issue where the
Yes, sir.
credit is denied? Okay.
Yes, sir.
See, as far as this matching concept is concerned, the according to me, the department will have difficulty in enforcing it. The reason is the law gives a machinery in the form of recovery provisions, and the department uh, cannot give up that power or refuse to exercise that power and catch a bona fide purchaser who has no control over the supplier, whether he has, when the mechanism in law is that it should be remitted to the supplier, supplier in turn remits it to the government. If that is the prescription in law, and of course exception being RCM, in those cases first even the department should take action against the supplier, and only in cases where there is a collusion between the supplier and recipient, in only in those cases they would be justified in denying the credit to the recipient. Otherwise, we have seen judgments in the past regime where they have been consistently holding that it would be very unreasonable. So I am sure when a situation comes, people would challenge those provisions in the court, and particularly if the department is dormant and does not exercise its powers against the supplier, erring supplier, then they would be hit by the maxim that they cannot take advantage of their own wrong. Next question.
Okay, sir. So moving on to the last query for today's session. Manish, the query is that can you summarize the decision of the Kerala High Court in the case of Sheen Golden Jewels, and also can you throw upon light as on today, if I receive any departmental notice for audit under service tax, what should be the stand? Shall I treat it that it is invalid, that the provisions of yesterday law cannot be reinstituted now, or will the decision of Sheen Golden Jewelers can be held up and department can proceed further?
Okay. I think, in fact, if you are to refer to entire case of Shield Golden, it would take another session to completely go through those facts. But briefly, I would say, uh, under Sheen Golden, the challenge is before the challenge of the petitioner was that Section 174 of the CGST Act or the SGST Act, it lacks legislative competence on the date of its enactment, which is 1st July 2017. It is a accepted principle that on the date you enact a statute, it should be the legislator should be legislatively competent to enact this statute. Now, in this circumstance, we have to see what Section 19 provides on the date of its enactment on 1st July 2017. Section 19, first of all, it says that any provision. Now, before that, I would say you have entry 54 in its pre-amended form, and you have entry 54 in its amended form. When it comes to amended form, the states are abrogated of their power to impose tax on the levy of sale of goods other than petroleum products. So as on 1st July, you have to interpret Section 19. Should you interpret Section 19 that the states have the power to impose tax on the Sale of Goods Act in re-amended form, or they do have the power to enact Sale of Goods Tax Act only on its present format? If you see Section 19, it says the provisions of the Constitution, so long there isn't inconsistent with this 101st Constitutional Amendment Act, they should be read down. They would not be applicable as on the date of either expiry of 1 year or the formulation of legislation. Now the petitioner argues that So long as the legislation is formed, those inconsistent provisions do not have any kind of legislative competence. So therefore, Section 19 cannot be used to provide state to provide any power to formulate, either to formulate or to recover taxes of previous tax assessment year in respect of sales tax. The other argument, one is the argument on the interpretation of Section 19. This is the argument of petitioner. On the other hand, the Sheen Golden, the High Court, in fact, holds that the Section 19 is not a saving clause. That is, it does not abrogate the state's power to levy sales tax after GST. It only says that once the state needs to exercise its power under Section 19, that is, they only need to make the laws consistent before the expiry of 1 year from the enactment of 101st Constitutional Amendment Act. As long so soon as they make these provisions consistent, these provisions that have been made up would be foreseeable, that those provisions would be applicable or effective for their entire duration. In a sense, since Section 174 was enacted within the legislative competence of Section 19 before the expiry of 1 year, once this section is enacted, it would continue to operate irrevocably, right? Now, it does not matter whether Section 19 has expired or not, the time period has expired or not. So they would say that Section 19 is not a saving clause, but it is a transitional clause. This is a basic argument, or the ratio that the code held down. Now, another formulation that is being forming out of that quote is, although it is not specifically stated so, it says that state also have the power to legislate under 246A. That is, they could fragment sales supply into sales and save the taxes that were earlier there within their jurisdiction, and formulate a saving clause in the GST provision itself. So there are the dichotomy in the first argument in the Section 19 is that whether it is a transitional clause or saving clause. If the argument of the High Court is accepted that it is a transitional clause, then for a academic discussion, had the state made a sales tax law, new sales tax law within that 1 year time limit period, would it have been continued to survive all throughout the period, even despite GST was there? So this is a very crucial point in the ratio that the court arrived. Now, the second point of the High Court is that that uh, it says that the power to legislate on previous tax demand is also traceable to Article 246A. Now, again, Article 246A, the mischief with Article 246A is that it is a tax on supply. If you see if you see 246A says that state and parliament have the power to make law with respect to goods and services tax act. It does not, 246A does not provide the wording supply. The wordings of supply are found in Article 366(12)A when it defines goods and services tax act. So when it comes to making the power with respect to goods and services tax act, one, first you have to satisfy whether my tax that I'm trying to impose falls is squarely coverable by the Article 366(12)A or not. Now, if you are happen to bifurcate 366(12)A itself and fragment supply into sales, then again you are pushing the sales from 366(12)A to Article 246A. Now you are pushing the power to make laws with respect to sales. The element of sales is not at all provided is neither provided in Article 366(12)A nor in 246A. While if you see Article 246A, 246A only provides for fields of legislation. It does not require the bifurcation into sales or service of any kind. So the fundamental difference between 246 and 246A is that 246 has a limited power with respect to a particular kind of tax. So you cannot say that I am I can impose the argument of fields of legislation under Article 246 into 246A also, because 246 is A is very categorically. It does not provide fields of legislation. It provides a subject itself. So Sheen Golden case basically is it on two counts. It has an observation. One, that section 19 is a transitional clause and not a saving clause. Second, it says the power is traceable to 246A. In my personal view, I would say both these arguments have its flaw. So I think I clarified the position on this regard. What was the second question, Arjun?
The second question was, what should be the rational stand as on today if I get the notice from the service department for reinstituting the audit? Whether
Okay,
I
I
should challenge the
assume
notice?
this. Okay, okay.
Yeah.
I assume this question is somewhat related to the judgment or the ratio that might flow from the interpretation of Section 90. But
Okay.
we have to be careful because what the argument in Sheen Golden case is that it abrogates the power of states with respect to power of parliament. Parliament still has its power, is residuary power available under entry 97. And keep in mind, 97 in its pre-amended form is not diluted from its present form. So parliament, the case of parliament with respect to service tax is little weightier than the case of state with respect to sales tax. So I would say if a way forward has to be seen, probably the assessee should participate in the list, at the same time maintaining before the authorities that he would be relying upon the ratio that is propounding in Sheen Golden case or any further subsequent development, so that a list could be open and any future development happens, if any future development happens, he is able to take advantage of the same. So probably he should reply to the audit notice, in my view. Naveen sir, if you have anything to say on this.
Yeah, on the first issue, I would recommend that the concerned person who has raised this issue should read the judgment of Sheen Gold, which is available in the public domain. Both the arguments for and against, and the decision laid down by the court is available in the judgment for them to read it. One more thing which I would recommend is that there is one book which is referred to in that Sheen Golden judgment rendered by Justice Naidu. There they would find this a book only on sunset clauses. In fact, I had purchased this book long back, even before the Sheen Golden case came. I was reading that very interesting book on the effect of sunset clauses in either a statute or in a constitution or in any other document. How you give effect to sunset clauses. So my view is that this is, of course, the Karnataka and Kerala High Courts have not accepted that proposition. With great respect, I feel that when a matter goes to the higher forum like Supreme Court, there can be a good case made out for the Supreme Court to consider it. And who knows, after winning the case, they may come up with an amendment. That is also possible. It has happened in the past. So, to answer the second question, if you receive a show cause notice today, you participate in the proceedings, as Manish also told, reply to the show cause notice. At the same time, you weigh the merits of the case. Do you have a strong case on merits? If it is a strong case on merits, you take this argument relating to 174 and 19 without prejudice. Because had 19 not been there, this issue would not have arisen. This has arisen because of section 19 having a sunset clause.
Okay.
So this will take some more years for the court to decide. So take this as an alternative argument, take an objection. The assessee has to take it, the department may not consider it in adjudication. Participate, then if some judgment comes, favorable judgment comes, take advantage of that. And if the issue is very weak on merits and stakes are also high, then you consider the possibility of uh, taking the same arguments as was taken in Sheen Golden matter, but be prepared to argue the case till the Supreme Court. The other alternative could be, if there is no merits at all, look at the possibility of a settlement commission. Of course, the Sabka Vishwas scheme, everything has expired except the payments. They are postponed now.
Yes, sir.
Yeah, thank you.
Okay, sir. Sir, last
Arjun, the
query.
book reference has been put in the chat box, so if
Okay.
anybody wishes to, yeah.
Okay, it will be shared. And sir, the last question asked by the participant, sir, on general doubt, in normal act, we are referring it as a section. So like in GST, we have some 174 section. Then why in Constitution we are referring it as an article instead of section? Is there any specific reason behind that? Naveen, sir?
See, I may have to read a little about it to give a specific answer, but the Constitution is not merely a statute. It is a living doctrine. So therefore, they wanted to have it as an article. Maybe if I read some material, I would come out with a better explanation. So it is not merely a statute. So there's a difference between the Constitution and the other statutes which you have. That is why they have called it as article.
Okay, okay. Sir, by this we have addressed all the queries of the participants. So by summarizing the end of the session, I would like to thank Speaker CM Manish Sachdeva for your wonderful deliberation on the topic, and Naveen sir for your valuable suggestions and inputs upon the deliberation by the speaker. And thank you Manish and thank you Naveen sir for
Thank you
your.
so much.
Thank you so much.
Thank you.
And I thank all the
We'll see.
participants for your patient listening. And we will meet up tomorrow with the topics on issues on GST refunds and how to limit the exposure of interest and penalty under GST. Thank you all.
Thank you. We will come back
Bye.
next week
Bye.
with legal maxims, isn't it, Manish?
Yes, sir. Yes, sir.
Yes, sir. Right. Right.
Thank you.
Okay.
So
Thank you.
Bye. Thank you. Thank you, sir.